This is a letter from the Chief Justice of the High Court. It says today is 6th, na?
Yes.
So it is today only.
These complaints.
It's another one. This is yesterday. He says, I deem it proper to bring to your lordship's notice the latest position in the exercise of SIR proceeding in the state of West Bengal. As on 6th April 2026 till 12.4 p.m., almost 12 o'clock. 12.04 p.m. 59 lakh, sorry, I was always wrong. 59 lakh 15,369 number of objections have been decided in the entire state by the judicial officers as against the total pendency of 60 lakh 6,675. So to my mind, by now it might have been
It should be complete. Yeah, that's very welcome.
Update name.
From the so-and-so reproduced below for kind perusal, then the data is given completely, bifurcating, found not eligible, found eligible, action taken, eligible individual, ineligible individual, total e-signed. Till issuance of this letter at 3:20 p.m., the data in the dashboard of the Registrar General has not been updated by the Election Commission of India. So that means information is
In process.
12 o'clock.
Yeah.
Those sent at 3:20 because by that time it might not have been updated. Do you have any latest one?
Yes, Millets. As far as phase one is concerned, now, as of just half an hour ago, 26,000 is pending. That will be finished in a couple of hours. And even phase two also, around 25,000 is pending. That could also be finished today.
Mr. Naidu, there is one thing, the electronic signatures of the officers,
Yes, ma'am.
for that you need to again reopen the portals for these officers.
We will do that, Millets. If it's required that they need
will
to
be
put their
required.
electronic signature, we'll
Because
have the portal access and then we'll do that one. But by today, the whole process would be completed is my information.
Yeah, that's fine.
Letter entirely.
Yes.
So there are two phases for the whole of West Bengal that we know. First phase 152 constituency of 16 district, then are going on poll on 23rd, then 142 constituency of 7 district on 29th April. As far as the district Murshidabad is concerned, which is going to poll in the first phase, had a total pendency of 11 lakh something objections to start with. As on yesterday, 5th April 26, the pendency was 45,229, which is not likely to be finished by today. So far as the other 15 districts are hopeful of finishing by today.
Yes.
The major pendency in the 7 districts going for poll in the second phase, as on yesterday, then it is given. And he says, are hopeful of finishing the pending objection of the 6th day by today, of the 6th district by today. The most notable feature of this SIR exercise is that district Malda, which had an initial pendency of 8,28,127, has been cleared off by our judicial officer yesterday, 5th April 26, despite so much of disruption, including Gerav and live threat to the judicial officers. I am enclosing here with a chart showing district-wise pendency objections done so and so. There are some cases pending on account of verification of documents reported to the state, and the state has responded by saying that the process is going on. At the final stage of the SIR exercise, a critical bottleneck has emerged regarding total completion of e-signature process. That is probably my
Yes.
brother pointing out.
We'll do that.
In respect of all parts in all the assembly constituencies. This is due to the absence of real-time, granular, officer-wise data of pending e-signatures across ACs stock parts. This lack of real-time traceability is affecting timely closure despite substantial overall progress. It has also necessitated reactivation of several login IDs of judicial officers, and the matter has been communicated to the Election Commission of India. So that probably you need.
We do that straight away, Millets. Millets, as far as the tribunal also is concerned, we have appointed a nodal officer to coordinate. Some prospective candidate mentioned in the morning, even that was disposed of by now. Yes, we got the information. That's been disposed of, Millets.
Now,
And the last,
this is the letter, Mr. Naidu, which the Chief Justice has sent to us.
yes, Millets.
We have received. There is one letter which just now I found it has been forwarded to on our mobile by Honorable Chief Justice. This is addressed to the Election Commission of India yesterday, 5th April. two, three small issues are there. Probably you need to, by now, we hope that you are resolved. As directed by the Honorable Committee presided or by, this is a letter by Registrar General to the Chief Election Commission of India.
Yes.
And there she is writing, as directed by Honorable Committee headed by Honorable Chief Justice of the High Court, please be kind enough to submit the report on the following. Three issues are flagged. One, when the venue of the appellate tribunal will be ready to be functional in all respect.
We have got the photos, it's been ready and we have handed over. Yes.
All right. Second, whether the circular stroke notification pertaining to payment of honorarium and other incidental expenses for the honorable judges of the appellate tribunal is issued.
We have requested to provide the details, my lord. So far, we have not got any. That's my instruction.
All right, you please do it.
Bills and account numbers we wanted, my lords, is said to be provided. It's been done straight away. We'll be doing it.
All right, you, if you are at.
We're in correspondence with
Can be done, then it is.
the landed registrar. We have been in correspondence with. They provided the details. We are doing it straight away.
That is very important. That
Yes.
may require a small judicial clarification that we will do otherwise.
Yes.
Whether receipts are being issued in case of appeals filed offline.
Millets now, they've just started trickling when it comes to appeals, Millets. The other day,
I
based
think
on your
for
lordship's
that-
directions, one was disposed of, the other disposed of.
Online acknowledgement is there, offline will.
Please, let me
His-
complete. Let me complete.
Yes, of course.
Online, they're getting acknowledgements as the proof. And physical, if at all they do it, Millets, I'll get instructions and supply to your lordships.
Your office is setting up the structure and you are having a nodal officer. Nodal officer will definitely sit at the
Yes,
place where the tribunals will be functioning.
yes,
So the nodal officer, as and when, either they get it online or if they get physically, they immediately give the receipt and give a number.
yes.
As the registry of any tribunal or court does, and the matter can be.
Online, we are already doing. Physical, I'll check and the nodal office would be instructed accordingly.
There is one more letter. In fact, I just forgot. That first time I'm bringing mobile in court. I have never brought in live. This letter is by Justice T.S. Shivananam, former Chief Justice. This was on 4th
It
April.
is there.
It is there. Appellate tribunal, they were discussing that what should be the, because we had said that in accordance with principles of natural justice, and that the appellate tribunal will evolve their own procedure. So they wanted some clarification that what should be that procedure. So Justice Shivananand sought some clarification about personal hearing. Personal hearing, no?
I remember my lords have said, we leave it to their discretion. If based on records, it could be decided, it could be decided.
No. Personal hearing order was there earlier.
Understood. We thought that the 2-3 of them are very senior former chief justices. We constitute their committee to lay down the procedure which each one of them then uniformly will follow,
Yes, yes.
so that there is no ambiguity.
Yes, yes.
Yes,
All right.
absolutely.
That's fine.
Milord, but hearing is concerned, Milord, by your lordship's order, earlier order. Your lordship's allowed personal hearing.
Yes, that we have. but what
Surely,
we
Millets,
are
my
saying-
lords have indicated that we leave it to them.
Leaving it
Yes,
to the
precisely.
Tribunal concerned to formulate their question.
Man,
Yes, but after
Milord,
providing
only
the
one thing,
parties
one thing.
fair opportunity,
Milord,
being
Fair opportunity,
Milord,
fair opportunity.
Milord,
Use the word probably fair opportunity.
There are
opportunity, my lord.
Milord, importantly, one thing is this. Online appeal, they have made a format. Now, Milord, online appeal, they have made a format. Beyond format, nothing will go. In the format itself, kind the maximum facts and reasons within 1,000 characters. There is no scope that the documents which we have given earlier to send that documents.
Approach the tribunal who can give a.
The point, it will not go to the tribunal even online. The appeal which is being filed online,
That 100 character,
1,000 characters, 1,000 characters.
1,000 characters.
10 characters will be used. If you say, we request the tribunal to permit us to put in additional documents in support of our. Isn't it?
The point is this, Malad, kindly.
But the-
Unless I'm told, Millards,
Malad,
it
kindly-
is not even
kindly
characters.
appreciate
We
this.
don't need to.
It is not
advise
even
the-
characters.
Documents
One
are
thousand-
engineered.
Malad,
So
kindly
Let's
appreciate this.
not be naive that new documents, Malad, at this stage are.
No, you have
manufactured
not
or
given the, you have not given the
Not
receipt
new
of the
documents,
documents.
not new documents.
Malad, yeah, they have not given the receipt of the documents.
We are fully conscious of the danger of new documents.
Yes.
That will.
I'm
Malad.
fully confident. Malad.
But-
Your lordships are aware.
But the thing is, there are in certain cases, failure to upload a document which is available. Now, in this situation, if we shut out that document, it will only be addition to the litigation. They will challenge this order in a constitutional court and get it remanded.
Yes.
This is why we discussed it earlier, and Mr. Solicitor, we said that we have got very experienced chief justices and judges. So they will formulate their procedure.
Their own procedure,
And
whatever.
Malad,
Malad,
the
as per-
another thing is,
it is-
earlier, my learned friend is saying earlier, the documents which were given by the persons, Lord, the affected person, they have not given the receipt of the documents. Number one.
Well,
Number
it's-
two, if 7 documents.
Many
have been
times it's
given-
been said, we have just nailed the lie.
That can be
Again, they are
the
coming with
ground
that
of-
one.
That will be one of the ground.
No, my lord was,
I relied upon this document.
my lord was,
We are giving you an example. Suppose somebody wants to rely upon a matriculation certificate. And he said that, look here, this matriculation certificate I had obtained in 2025. It is not that first time I am getting it. I relied upon, I have no reason that I will not rely upon. This is my matriculation certificate obtained by me in 2025, but this officer have not considered it. We understand this argument. Tribunal can always examine that.
But
is not a
only one
document
thing
that
is-
today somebody has
my
obtained.
lord, only one thing,
Just-
kindly just,
Just the opposite.
my lord, excuse me.
Matriculation certificate obtained at a contemporaneous time, what Mr. Solicitor is pointing out, you have plethora of birth certificates coming out in 2024-25 in respect of births of 1990, 95.
But-
Those become quite suspect.
Yes, my lord, kindly see, your lordships was pleased to direct on the other day. The problem is there. To eliminate any doubt, we request the appellate tribunal to revisit the full records. My submission is this, my lord. The records which I have given, documents which I have given, that all the documents are not there. That is I am saying.
That precise argument you will raise before the tribunal.
Tribunal, that indication.
No, since your lordships have, my lord, said that is to revisit the full records. And when the, my lord, the formalities will be adopted by the.
Describe a document which is not a part of the records. First, Mr. Bandyopadhyay, whoever makes the appeal, grievances have been expressed to us that they do not know what is the reason for their
Correct,
rejection.
correct.
Correct?
May I submit one
What
thing?
records are there? That is why we clarified
Yes.
that all the records as well as the reasons will be made available to the tribunal concerned. You make a first prayer that you
Madam,
please share the records
Madam,
and then you controvert that no.
My lord, disposal,
Well,
of-
let's-
the entire
my-
record.
my lord, disposal of the first appeal by the tribunal Justice, my lord Justice Sivanganam has said that no reason could have been placed before the election, the tribunal itself. What you are saying, that's correct, my lord. First appeal which has been disposed of, reasoned order, there, despite the chances had been given to the election commission, they could not place any reason before the court.
Millards, it's not we who are deciding.
Just have a few.
It is the judicial officer that decide.
So to appellate judges to consider that.
Millards, may I just make a few suggestions?
Millards,
and
my
requests?
lords have said about
Just
the
a few,
physical,
since we are
physical,
focusing our
even
attention
when they
now.
have submitted
I just
physically,
have a
we are
note, 4
digitizing, we are
paragraphs.
uploading, and we are giving ticket number to that one.
Yeah, give it
And
here.
Millards, as far as the procedure, Millards, it's fallen from your lordships, an SOP could be given by the senior most tribunal members, Millards. It's absolutely the best way,
Yeah, that's
in my
probably,
humble submission.
that's probably fair.
So
No,
that
Millards, sorry.
neither of us have anything to add to that one.
Millards, I think the focus now shifts because there's an enormous exercise done, 60 lakh cases. It's a remarkable exercise and really the judicial officers have to be complimented.
But today the Today, the other concern which we were really slightly concerned, that has started emerging, that because of now this entire exercise, court cases have really
Yes,
gone to
yes,
the
you're
back
right,
seat.
you're right.
Yes.
yeah. So, yes. so
I
this
believe
will have to
it's
be
now by
completed.
today, they would be,
And this
as far as
much
the judicial
officer
officer are
now
concerned.
will have to deal with those
I
court
know.
cases also
And the
day and night.
backlog, yes.
It
Yeah.
is they only who will have to.
Anyway, we are grateful, Manoj, your lordships may really record our appreciation for the service. Now, Manoj, it shifts to the tribunals. Now, here I just have 3-4 points. I've given a note. I'll just indicate. I hope it's been given to the other side. Yeah. So, Manoj, I'll start with paragraph 3 of the note. Out of these 60 lakh cases, available data of 44 lakhs cases indicates that the inclusion rate is about 55%, which is 24 lakhs, and the exclusion rate is 45%, which is 20 lakhs. The rejection rate appears to be very high despite the judicial safeguards. This is keeping in mind, Millard, that these are all mapped individuals. Now, para 4. Out of the 20 lakh published cases of deleted electors, almost 7 lakhs have already filed and several lakh appeals are in the process of being filed. This is our understanding. This court notified the appellate tribunal on the 10th of March. However, the appellate tribunals are yet to be fully operationalized. What we mean by this is functioning in, just as the judicial officers were, because there were some hiccups, etc. Very few appeals were taken up by the 19 appellate tribunals so far. That's our information. Now, this is a cause of concern, Manoj. B. There are long meandering queues formed outside offline filing facilities, and electors are opposed with great difficulty for filing an appeal promptly. There are news reports, Manoj, we've given some photographs, very lengthy. Yes, on the second page, your lordships will see, for example, lengthy queues are developing over here just for filing of these appeals. Para 6, in the first phase of elections in West Bengal, in respect of 152 assembly constituencies, the last date for filing is 6th of April 2026. The polling day for this phase is 23rd April 2026. For the second phase, the dates are 9th April and 29th April. Now, please focus on para 7. This honorable court may consider requesting the tribunals to dispose of all appeals filed by, and we have suggested a cutoff date of 15th April 2026, so that the final supplementary electoral roll can be published by 18th April 2026, which is 5 days before the polling date. And additionally, in the case of those mapped electors whose appeals remain pending beyond 15th April 2026, this honorable court may consider allowing such mapped electors to be included in the electoral roll. This is our suggestion. This is because, my lords, the appeals being in continuation of the adjudication process, and no elector should be disenfranchised. These are mapped people. They voted in the 2002 elections.
Be fully
Sorry.
conscious of your concern.
Yes.
And in fact, in continuation of that, we had said that the appellate tribunals should look into the continuum of the constitutional right, which appears to have been adjudicated
Yes, that's a correct
within a
approach.
short window
Yeah.
for the purpose of having the maximization in participation.
Yeah, I think so, Manoj.
Right.
That's fair, Manoj.
But to now compressing the appellate scope in that event will again result in a very hasty exercise. It may
No,
not
may
be
I
advised.
just, Manoj,
May not be advised.
Manoj, we have made the point. The point is, Manoj, the request is that the tribunals,
We have consciously done that
I'm
the
grateful.
exercise of logical discrepancy being a layer introduced specifically in
Yes.
respect of the SIR for West Bengal required an independent adjudication through the judicial personnel. And in exercise of that, we have thankfully, through the enormous efforts of these judicial officers,
No, but there's no doubt, Manoj. Otherwise, these 60 lakhs would have been out.
closure of all the 16,000 logical.
That's a remarkable
Now,
achievement.
where we need to draw a line, and you know that in all cases, whenever you have
Manoj,
classification,
but what about the tribunal?
to have a rule of thumb.
No, I'm just suggesting that as far as the tribunal's functioning is concerned, because Manoj, they cannot be, sorry.
two concerns are very important, that tribunal should become functional immediately. There is no doubt. about it.
Because we are told that, Manoj, there were no places to sit, desks, etc. were not
Every hour
available.
can-
Tables.
Every hour can have its own impact and material impact.
May I make a?
So that I think they have taken care of that aspect. Rest is, of course, we will request the tribunal.
May I make a suggestion?
They are well-
Could my lord see the
May I
arrangement that
make a
were made
suggestion?
minutes?
My suggestion
Yesterday
is the
itself I have
following.
done that one.
If you
We have
don't mind, just
requested
one
they
second.
could shift over. and
Just
down
one
five.
second, Mr. Naidu, wait a minute, please. My suggestion is your lordship may be right. X number of people, appeals will be filed, will be disposed of, Y number will be left. Malas, can there be also a power for an interim order, Malas, weigh those? At least, Malas, what happens is prima facie, you know that this appeal will be allowed, this order cannot be sustained. That will quicken the process, Malas, allow X number of more to be done. Malas, that power your lordship should give. Your lordship having an appellate authority will have that power. In any case,
that
appeal
will
power
also-
includes an interim order, Malas. Therefore, my suggestion is,
We will leave to the appellate tribunal that.
that's all I'm saying, Malas.
After-
I'm not saying anything more, Malas.
Mr. Simple, like we did not appreciate the shift of any qualifying date for new entrants, fresh voters, etc. At the same time, when there was this large bulk of logical discrepancies where the ECI officers flagged certain very peculiar trends.
Yes.
Peculiar as well as
Yeah, yes,
disturbing at times. We need to have an first instance adjudication.
Right.
And that adjudication or
Has
we would
happened.
rather say not adjudication, verification.
That's correct.
A verification done.
Right.
There we need to freeze it.
No, I agree, Malas. I'm not saying
Sir, the
your lordship is freezing it, Malas.
the last date of nomination, though not technically the qualifying date, because the qualifying date, if we go, it will relate back to the day on which the final list has been published. We
28th,
exercise of
28th of
Article
March.
142 have extended or deemed
Yeah,
to
yeah.
have extended to the supplementary list. And we feel now the last dates of nomination, if the verification of all the doubtful or the logical discrepancies done, we will allow the ones which have been given the nod to be incorporated in the supplementary list. We will make necessary.
But the tribunals will
That's
be
great.
hearing,
My
one
lord,
second.
I
But the
appreciate that.
tribunals will be hearing matters
But
allowing appeals.
tribunals will go on hearing, and we do not want to rush this exercise.
No,
either
no,
for
no.
the
I'm just
tribunal
saying where the
or for the
interim orders
affected
can.
persons, so that they do not fall prey
Malas,
to a
Malas, a full hearing requires a full
lord-
hearing.
my
Malas,
lords
where
have
there's an
very
interim
felicitously
order passed,
observed.
can pass an order. That's what I'm saying, Malas.
Can you give an interim order, Mr. Simple, where the final?
If the birth certificate was uploaded, was not
Malas,
uploaded and he has it,
initially,
Malas, or
since
some other
judicial
document
officers
like
have
the
been
passport.
adjudicating
Malas,
minutes,
your lordship saw that
I'll
in the
submit.
morning, the express news, there was a passport that a person had. Malas, on that, a prima facie order can be passed. Therefore,
May
leave
just
it
add
to
that,
the
Malas.
tribunal, Malas. I'm not saying anything.
It
Leave it
cannot
to
be-
the tribunal.
Consider the first phase election.
Yes.
The lists are being published, and we may at best say that by tomorrow, the supplementary list, including everyone
That's the end of.
in the 152 assembly constituencies, will be frozen. Let us say on 10th, we are sure that the next category, 16 lakh and odd, will be frozen, but then subject to the verification of the judicial officer. Persons aggrieved will be entitled to file appeal.
That's right.
Mr. Bordopathy expressed concern. The appellate authorities will formulate procedure by
Correct.
principles of fair procedure and natural justice are followed, and a final order is passed.
But-
That may take a month, that may take even 60 days.
Malas,
We cannot on that contemplation
You-
put in some people because they were earlier mapped.
Malas, one,
There may be people, Mr. Diwan,
but an interim order can be
not
passed.
mapped, more compelling than cases of map and their progeny of a person who has 100 children. Those are.
My lords observed on the last occasion itself, your lords told us,
Just one.
let the process go on, notwithstanding the elections, because it's for the future.
Constitution, whose family has generationally lived in Shantiniketan. His grandson has been Nandalal Bose's family has been deleted from the electoral roll. we would not have any illustrations in the constitution if not for his grandfather.
You please supply.
How we examine the
names
individual
of-
facts.
you
I
please supply the name
right
to.
now,
Mr.
Who do they want to blame, Millets? Millets, my lords have appointed,
That is treating.
my lords have appointed judicial officers?
At the beginning of this exercise,
Yes, Millets.
noted the lack of constitutional entities having a trust deficit.
Absolutely.
Our exercise here under Article 142 is not of apportionment of blame, but of enlargement of voter participation.
Precisely. Grateful, Millets.
However, keeping in mind that the constitutional right of the Election Commission to purge a list and remove entries which are incorrect
Yes.
is well taken and given its proper expression.
Your lordships have been generous
Particular
in
situation
extending
as
all the
Dr.
limits,
Swami
all the time
pointed out.
frames.
Unique situation.
Now, Millets, my lords, may kindly see.
Mr.
Judicial officers have examined. Judicial officers have examined. And then whoever is aggrieved, they are filing appeals. And they do take time. It is they who failed in convincing the officers.
It will be definitely considered.
Of course, Manoj, there have been many like this.
My lord, one
Many
request,
like this.
one,
Like this, Mr.
my lord,
Football.
my lord,
Yes.
kindly-
We are trying to maximize.
I know that.
But again, as she's pointed out to Shantiniketan, we will point to Tagore and say that the trial is striving, trying to stretch its arm towards perfection.
That's,
But may not always
I
reach.
agree, Manoj, but some
Precise.
via media. it's
my
not
lord, one request to your lords, my lord. Kindly see, my lord, after the, my lord, the appellate tribunal decides the matter and allow
So close, Karnai.
Tribunal was 10th of March. I'm just suggesting. So now till date, your lordships have seen that from 10th March, there is no efficacious disposal by the tribunal so far. They've done a few cases. Now, my lords, we should not completely negate that tribunal exercise. Now, if the tribunal is to consider, then there ought to be a supplementary list, my lords. It can't be frozen
My lord, kindly see, my lord.
without the appeals
My lord,
being heard.
It's an impossibility.
Kindly
Millets, in my
one
humble
request.
submission.
My lord, kindly one request.
May I just- may I
One-
just read, Millets?
We are completely silent on this issue. Please let us, they are former chief justices and judges. Let them resolve their own procedure. We are only requesting them, they will constitute.
No, that's
No,
not
no,
the
fine.
procedure.
That's the kindly one,
Question is,
one request. My lord, after the tribunal is decided in favor of the any persons, his name is cleared by the tribunal. Then, my lord, before the election, day, let's take it 23rd April, the first phase. Up to 21st, whatever the names are cleared by the tribunal, my lord, they should be allowed in the supplementary list.
Mr. Bhalwati, realize
Isn't they
the
should have picked a
enormous
timeline?
pressure that will fall upon.
I am not saying, my lord,
Millets,
Manoj, the RP.
once that,
There is a-
as my lords have
there is
famously put,
sufficient, sir.
Millets,
my lord, kindly see, I am not talking about.
once
Please appreciate the difference in the nature and quality of the proceedings before the
Well,
appellate
I am not-
tribunal vis-a-vis the verification of a judicial officer.
I am not talking about.
Judicial officer has verified in the form of an ex parte exercise. Today, it's here is a exercise with the requirements of adjudicatory natural justice.
My lord, I am not
And
talking.
there, if this pressure is put on the tribunal, how
My lord, I am not talking about the number of disposal. I am saying, my lord, let's take it, 100 cases have been disposed. Let's take it one case. 100 cases have been disposed of up to 21st, first page is 21st. That, all that disposed of case in favor of the persons, my lord, they should be included in the supplementary.
it is not,
That's I am trying to say.
So we are looking,
you have
we are
failed,
looking at a figure of around 26 lakhs. Appeals, let us say within 7 days will be crossing lakhs. And each and every one would love his case to be decided. 19 tribunals, a race to the finish by 15th of April will create chaos.
I am not saying, my lord, kindly, I am not saying about.
Another problem. Why this?
Every day, my lord, kindly.
My lords, your lordships were
Yes,
not even inclined to have an appellate provision initially. Said it's judicial
every
officers,
day-
they will do it fairly, that's the end of it. Then your lordships said for future purpose, they should have that one. For that purpose alone it is.
Otherwise, my lord, the state of
They can't stretch too far.
Also see the hypothetical comparison, say with the appeal. Now civil court, assuming, has dismissed the suit. The first appellate court decrees. The objector has a right to go or
No,
not.
that is all right, my lord.
Precisely.
But kindly appreciate this, my lord. Let's assume, my lord.
Voting right, my lord. This is
It's
a
question
voting
of
right.
right.
That
but
drives
that's
home the
not
point.
Let's assume, my lord, tomorrow,
Let us first create that environment so that the tribunals are able to maximize the disposal.
Yes, yes.
Let us first create, we are not closing today also the matter.
Very well.
We are keeping it pending.
All right.
Just to take care of what you are apprehending or anything, we will keep the matter again.
Yes.
this thing.
Fair enough, fair enough.
Yes, very well. But some supplementary list may be necessary if the tribunals are made functional.
That would amount to changing the dates prescribed. under
No,
the
no change in date.
And representation
No
of
change.
people elected with
You have
conduct of
changed
election
everything.
rules.
You have changed everything. You have destroyed the democracy. You have changed.
That
everything.
we have to say something. On destroying the
Yes.
democracy, we have to say something.
May I
Yes,
submit
you
one
have
thing,
not
my lords,
started
since they are
up
talking
everything.
about, Millets, I need to be-
Made elsewhere.
Millets,
Sure.
my lords
Sure,
gave on the last
submission
occasion,
is not
Voters-
law.
voters'
Millets,
rights
my
have been
lords
taken away.
permitted us to deploy forces as are required because the safety of the office is very important. And we have been doing it in that process. Kindly similar yesterday's speech. And just, I don't want to,
Something
Millets,
really,
kindly
really
similar,
serious.
it's been said from Uttar
Can I-
Pradesh,
can-
CRPF people are coming to beat you. Be
Please,
prepared to
please.
face.
Let me,
Kindly have it.
200
let's not-
chiefs of
my
Can we
lord,
see Millets? Can we see the speech?
I-
Come to
Can-
beat you.
should I give another,
Very provocative speech.
should
yeah?
I give another?
They don't want a solution.
Then you have to say.
Kindly have it, Millets. And Millets,
Political
a
leaders. will have
judicial
to be-
officer,
Lord, it is
a judicial officer was crying, please, anything
If you
happens
don't
to me,
mind,
save my
Lord,
children.
kindly,
tell
kindly
the
have
court
an
what
officer. Only a minute.
been made
Come
by-
on, I also saw that. One lady
Well, the
judicial
Union of
officer
India has no role to
was
play in
under
this.
siege is recorded by a journalist crying that my life is in danger, my family is in danger. If something happens to me, please take care of my family. I would request
Yes,
him,
but-
as that,
Yes,
he please
we have had
show it
everything.
to the court. My lord, what is the
Yesterday.
situation, my lord?
First,
Uh,
They are,
see that
my
one,
lord,
my lord.
This is not fair.
they are all, they are not the procedure.
To hear Millets, I can play it here itself.
This is not fair.
But increase the volume. There is
That's the first one, please.
increase the volume. Better increase the volume.
Kindly press on
No,
the
we-
button, Millets.
My lord, volume will have to be
Yes.
increased. That's what Mr. Naidu says. You know how to. I
Yes,
don't.
yes.
Where is the sound?
Millets,
Then we have.
yes,
to
Millets,
the prime-
perhaps the younger generation could guide your lordships.
Don't.
No, my lord, the Chief Justice and other honorable
Let's
judges are
not,
also young,
let's not talk of.
relatively younger.
Then don't say about speeches, then we have to take the prime minister. What the prime minister has delivered.
Yes,
Kindly,
please,
only a minute.
Yes.
Listen to this.
We will also.
less than a minute,
Listen to this. This is not a speech.
less than a minute.
We will also show.
Please,
Prime minister's speech.
don't shout down, let it be heard.
Well, this is not fair.
Uttar
Malad.
Pradesh, yes?
This is
Can you
not-
deny that? Why not? We have been given the task of, Millets, we have been given the task of safeguarding the officers. And these are the speeches.
See now, my lord, the judicial officer, at least other side would have the respect for a judicial officer.
Judicial officers at the end of the day.
Where is the ECI's neutrality in
Carry
this?
your lordship's
a-
extended limb.
It's an election candidate speech that the ECI is showing.
He's a judicial, she is a
Yes.
judicial officer.
Judicial officer, that we have.
Will somebody take care of my children?
You are now diverting the.
Compared to face.
Who is it?
This rabble-rousing, this incendiary speeches will vitiate the atmosphere. And my lords have been doing everything to see that it goes on on an even keel.
My lords, Mr. Giri is logged in.
Lord, can I make a submission, my lord, with reference to the order that your lordships had passed on 1-4? Sorry.
There is no question of withdrawal of forces. The way the things have happened in the past, they are absolutely needed. And if the state machinery fails, you let us know, we will see what is to be done.
So be it.
My lords,
Lordship's
Mr. Giri.
extended limb, the judicial
May I-
officer is
may I
crying
make a
before the
sub-
camera.
But
He is
why
the
should
most
the Union
pathetic
of
thing
India
one can see. Forget
be
politics.
saying all this?
I'm not on.
Now, my lord, now, my lord, he was talking about this speech. Now kindly hear this speech.
We are not, we are.
No, no, no. My lord, kindly hear this speech. Chief Minister has been said he will be killed. Kindly see.
Anybody?
He was talking about peace.
No.
Done next.
All must have done it
The
because.
person on the street speaking and the chief
And
minister
then-
speaking have
and
entirely different connotations, my lord.
She will be killed.
The one who has to
That's all.
safeguard the people.
Problem is happening because
I know.
Showing
My lords,
because I can
my lords, if for a moment,
expedite the hearing of the tribunal in respect of.
100.
Tribunals
Now to decide, my lord.
on 20th March 2026, before whom the order, the decision taken by the judicial officers while disposing the objections in the SIR process, could be challenged. These appellate tribunals are headed by former Chief Justices, stroke senior judges of the High Court. The premises for these 19 appellate tribunals was shortlisted and detailed, the premises shortlisted for the functioning of these appellate tribunals is duly mentioned in para 6 of our order dated 1st April 2026. We also clarified through para 9 of that order that the alleged non-availability of reasons for rejection of the objections by the adjudicating officers would be raised before the appellate tribunal by the persons whose names have been excluded from the voter list or by such objectors stroke authorities of the Election Commission of India who might be aggrieved by the inclusion of certain names in the voter list. Next paragraph. To eliminate any doubt, we requested the appellate tribunals to revisit the full records, including the reasons assigned by the judicial officers. It was further clarified that the appellate tribunals will be free to evolve their own procedure in accordance with principle of natural justice, and that they may provide a fair opportunity of being heard to the parties while deciding the appeals. Next paragraph. Meanwhile, a letter was received by Honorable Chief Justice of the High Court from one of the former Chief Justice who has graciously consented to preside over one of the appellate tribunals. There, the issue regarding issue regarding inverted commas personal hearing to the affected party has been pointed out. Next paragraph. In this regard, comma, it seems to us that with a view to bring uniformity in the procedure to be followed by all the 19 appellate tribunals, comma, it would be necessary that that such procedure is formally prescribed before adjudication of the appeals. Consequently, we request the Chief Justice of the High Court at Calcutta to constitute a team of 3 senior-most former Chief Justices stroke judges who may lay down the procedure to be followed by the appellate tribunals. They constitute a committee of 3 former Chief Justices stroke judges who shall prescribe the procedure which shall be mandatorily followed by all the 19 appellate tribunals uniformly. So we request Honorable Chief Justice to constitute this committee immediately and let the said committee make an endeavor to prescribe the procedure by tomorrow. By tomorrow, so that the appeals can be taken up for hearing immediately. So as to expedite the adjudication of the appeals. Firstly. We further find from the record that Registrar General of the High Court at Calcutta has requested the Election Commission of India via an email dated 5th April 2026 to clarify certain issues, namely, when will be the venue of the appellate tribunal be ready to be functional in all respect. We are informed by Shri Naidu and Senior Counsel for ECI on instructions that the venue of the appellate tribunals is that the necessary, the requisite infrastructure has been made available, and the appellate tribunals are ready to function from the allocated premises. The second query pertains to the payment of honorarium and other incidental expenses to the former judges of the appellate tribunals. So in this regard, the Honorable Chief Justice of the Calcutta High Court you want their accounts to be obtained, may obtain the account number of the former. The account number and the bills from the former judges, former Chief Justices, stroke judges, and the Election Commission of India shall make necessary payments
Upon raising the bills.
along with honorarium without any delay.
Notification.
No, you have received the recommendations from the Chief Justice.
Accepted.
Huh?
We have accepted the recommendation and communicated, and this is.
Those recommendations accepted and communicated, Millers.
Yes, but
If my lords are talking about
that's an
the bills, Miller, they have to be raised and we'll pay.
the official notification by the election commission is required.
That's been done minutes ago.
No, the notification.
That has not been issued. That need to be issued. also.
Well, I'll just check minutes.
Yes, please check. If not, then by.
If it's not been issued straight away, it could be issued.
Tomorrow or day after
Yes,
tomorrow.
yes,
please
yes.
issue the remaining
Commission should strictly restrict.
And other medical expenses to the honorable judge of the appellate tribunal, let the election commission of India issue a formal notification stroke circular tomorrow, that is 7th April 2026. And let the necessary payments as per that notified rate be made to all the members of the appellate.
We'll coordinate with the Honorable High Court and we'll get all instructions and then we'll just accordingly comply with that one.
That's the third issue, equally important, pertains to the receipts to be issued in case of appeals to be filed offline. Mr. Naidu and Senior Counsel for the Election Commission of India informs that
It's been appointed.
nodal officer has been notified and he who shall be required to issue a receipt stroke acknowledgement of filing of the appeal offline.
Available at the place where the tribunal.
Shall remain available in the premises where the appellate tribunals have been notified to function. Also, maybe one nodal officer may not be sufficient.
If necessary minutes, we'll have it. We have just begun that process based on the inflow of the appeals minutes. If necessary, we'll just supplement.
Sufficient nodal officers shall remain present in the same premises where the appellate tribunals are functional.
My lords, offline modes are been placed with DMs, BDOs, etc., and SDMs to receive these appeals. So the tribunal is functional in Calcutta, but the offline mode is in all the districts.
No,
Millets.
very difficult. You see, from
This is the
how
online-
to
No, in that case, let the DM maybe direct.
My lord, in the initial, may
Yes,
I
all that
assist, my lord?
appeals to tribunals.
wants to file.
My lord, in the initial note,
Online, you can file from anywhere. Nowadays,
No, but many people.
But there are village people
Once they
that
can
not.
file, we can
get
take
lot
it
of
first.
complications. Tomorrow, somebody will say, I had handed over appeal to the nodal officer. He did not submit it on time. It will create a lot of complications.
But
My lords, this is what is happening. They're lining up at offline posts all over this.
Offline, we have filed the appeals, offline files. 7 lakh files have been,
Election commission.
offline files have
There
been,
is no compulsion for anyone to come to Kolkata. They can file online then.
there is a
problem already
in cases
where there is no match. They don't have the capacity to file online, my lords. This is true for
No,
the.
no, online is cheaper than the offline.
My lords, the problem is. the
Online is much cheaper than offline.
online and expects that you should be able to use the internet, OTP, phone, uploading documents.
Throughout the
capture,
country, internet connectivity is fully satisfactory.
My lords, this
this
voting.
technical training has,
Booth,
my lord,
vote.
technical
We have
trainings have not
Loads
been.
of people coming, my lord.
To the appellate
The
tribunal,
election
My lord,
commission's
yes, with the-
notification, my lord.
Dr. Lighadan will resolve procedure.
My lord, technical trainings have not been given to the voters.
For the appellate, it
This is
will
the
be for
election
the committee
commission's
to
notification.
further decide as to whether all the offline appeals will be required to be filed in Kolkata or such appeals can be entertained at other places also, at other designated places also. At other designated places, maybe 2-3 places can be. One can be on the extreme, not that every district there will be, there can't be any.
Well, kindly see
Coordinate with the
the
tribunal minutes, we'll coordinate with the tribunal.
election commissioners,
This is the
kindly see.
election commission has devised. And it's a very fair process.
They're
and
working.
and it is working.
So there is already a notice. issued by-
Yes, yes.
We have-
In the district, my lord.
There is no need, madam, for any.
Yes,
No, they have already said physically at the office of DM, SDM.
That's not-
Yes, yes.
They wanted to make a hue and cry of everything. That's been where, even before they could raise, we have visualized and we have done that one. All that they have to do is go there and give there.
You-
And millets,
Why
we are
you can
digitizing,
see
even
the
if they have
human
given
right?
physically, we are digitizing and we're giving the acknowledgement.
The-
Fantastic.
My lord, the,
Vote, my friend.
my lord, the problem is whatever I am, we are saying Mr. Naidu is opposing. He has taken an oath to oppose it.
The less said, the better about.
He have forgotten the what notification have been made.
Can't vote.
That's why you want the people to be harassed.
Exclusion Commission. Exclusion.
Exclusion Commission of India.
Lord, can I make a submission now?
Wait.
Wait.
Order is being dictated, huh?
Sorry.
দেবাঞ্জন ওরা বলেছে ট্রাইব্যুনালটা ফাংশন শুরু করলে পাঠিয়ে দেবো বেকার
In offline mode, the office of the DM stroke SDM stroke SDO will issue the requisite receipt stroke acknowledgement of filing of such appeal. That takes care of it. Now, this is also then say,
so far the documents part is concerned. Documents,
it's done.
No, billing first.
Already.
Seven.
Right.
Since, how many are left today? Now,
Millets, about 1 hour ago or 1.5 hours ago, it was 26,000.
That will be
In phase one.
completed, Bharat.
today probably it will be over.
It must be.
Yes.
By tomorrow, whether electronically sealed,
Tonight.
signed or not, should be uploaded as a part of the supplementary list.
Since we are.
Tonight itself, we are doing it.
We are
That's what.
informed that the entire exercise of deciding objections in the SIR process is likely to be completed by the judicial officers today,
Tonight.
the Election Commission of India is directed to publish the supplementary list tomorrow.
Millets, tonight, millets. Tonight,
We'll have
we are
to, as
issuing.
per the
Once
date
that's
fixed.
completed, we are issuing it.
The statutory
Right.
dates are fixed.
Tonight, so digital signature,
Whether
even in the absence of digital signatures on all the verified objections, full stop. For the
Yes.
digital signatures, the portal shall, for the limited purpose of digital signatures, the portal will remain open till
and be completed by 7.
uh,
Today you upload it. By 7th, they will digitize, put their.
Yes,
digital
ma'am. That's only a ministerial job of technicality.
remain open
24
till,
hours will be.
on 7th also, for the purpose of digital signature, for completion of the digital.
Millets, even that portal open and completion of electronic signature, etc., could be completed tonight.
We are giving
Yes,
24
the
hours.
leeway.
All right.
Yes.
That technically the supplementary list comes out today as the last day, but digital signatures may be done till tomorrow.
Beyond that also.
Post this matter for
Great.
further
And this is with
consideration.
regard to 52 assembly.
Yes, ma'am.
constituents.
Millets,
Can I make a submission now?
Further hearing on?
Millets, when would your
What-
lordship
Millets,
place it?
one last thing, Millets.
Millets,
My
when-
lordship
what's the date,
stated
Millets?
last time
Millets,
that
date,
By
date,
compliance reports, Millets. Compliance. Last time we lordships
Millets,
indicated that
next date,
Lord, before that, my lord, there is one IA by the 88-year-old grandson, my lord, of Nandalal Bose, who has illustrated the Indian Constitution.
You already told Mr. Naidu to look
My lord, if they can,
Light minutes we're addressing.
well, I'll speak to Mr. Naidu, my lord.
We have to help.
If
Mr.
that-
Gupta, it will be definitely done.
Lordship.
Next date.
Lord, can I make a submission now, my lord, if your lordships have
I'll be sure
finished
that-
dictating now?
Let's have the date first.
My lord, date.
that that the office of the ECI shall provide full assistance to the applicant in IA number 10223.
323.
May I say one thing, Millets? If that's been deleted or not accepted by the judicial officer, if they file an appeal
Yes, yes.
tomorrow, we'll assist them in processing that one.
Yes, yes, my lord, we have filed.
So appeal can't be submitted.
No, I'm not asking for that.
Your constituency in all probability does not go to poll on 23rd.
Maybe, my lord, he is in Birbhum district, my lord, Shantiniketan.
We are better
Lordship.
than you. So it goes on 29.
Right,
isn't it?
right.
You got adequate time.
No, I have already,
Advise,
yes, yes.
Mr.
My lord, we have already advised, he's probably filed it today.
Let them file the appeal.
Yes,
Give
yes,
particulars to Mr. Naidu.
I'll give that.
Will ensure.
I'll do that. I'll do that.
1022323 of 2026. Since we have created the mechanism of appeal before the appellate tribunal is constituted separately, the applicant may
Yes.
avail such remedy and file the appeal before the tribunal. In that event, Shri Naidu Learned Senior Counsel for the ECI assures that necessary assistance shall be provided to the applicant
In processing the appeal.
for effective adjudication of his appeal. The appeal filed by him or his family members well before the well before 29th April 2026.
Whenever that's possible, Millets, because
may I
once
just
they have to
request,
formulate
Lord-
all the other things and other things.
Lord, can,
Since your
can I
lordship
make a
is
submission
indicating a
now?
date, could it
The
be
problem is,
Friday?
Millets,
Yes, yes.
You don't worry.
if at all is the second phase, it should be decided before 9th. Millets.
Yes, yes, it will be.
If they file it
filed
tomorrow, we'll assist them.
Oh, he's filed today. isn't it?
So be,
So
my lords,
we have already
your lordship
in
said
earlier
the
order
month
said.
it was there, it was disposed of by now. The same way we'll do that.
Then in IA number 1022323 of 2026, we are informed that the applicant spoke his family members have already filed appeal before the appellate tribunal against exclusion of their name from the voter list.
Yes, please.
If that is so, we request the appellate tribunal to take that appeal
On Monday?
on Monday.
On Monday?
For final hearing. Shri Naidu Learned Senior Counsel for the ECI assures that necessary assistance shall be provided to the appellate tribunal for adjudication of the appeal on the date.
Millets, may I
Let it be
request that
placed
the main
before
matter, your lordship.
Would your lordships kindly take up
Would that be
IA
on Friday?
102130?
Would your lordship
Hear
consider
it on Friday.
on Friday?
Friday, my lord, your lordships may take up the matter again, your lordship said. Next hearing.
Next hearing.
Friday is not possible.
Then could it be next Monday?
Monday, my lord?
Monday, my lords.
Mr. Giri is,
The appellate, let's see.
So
that
we'll
also.
have some idea of how
Some
the
idea.
tribunals are
That's
functioning.
right.
That's
How
the
many,
real
how
purpose.
many cases they have disposed of, my lord, we'll have some idea. It's in that context only, my lord.
Appellate we will take up on 17th then.
would my lords only hear Mr.
If
Giri?
we got a little
Lordships
late,
can
my
we
lord.
swear in your lordship?
Get a little late, my lord.
Could it be a little earlier because 17th will be very close to that deadline.
Monday,
Please give
13th,
them
your
some
lordships don't mind.
minutes
my lord.
for the
Comfort
tribunal
when your
to
lordships
formulate
have-
and
here's
just
the
function.
my lords.
Next Monday.
We can
Nobody
be here at
read
4,
in
my
their
lord.
backs.
This should not take much time. It will take. Appellate on 13th.
But
Great.
Mr. Giri is
My lord, could your lordships kindly,
So
could your
great.
lordships kindly take up IA 102130?
We are coming to that. We are coming to that.
Yes, my lords. Yes.
What time, at 4 PM or earlier, my lord? On Monday?
Oh, no, there's one more.
It will be 2 PM.
2 PM, obliged.
Your lordships kindly have a look at the order that your lordships had passed on
Will
1st of
occupy
April.
time. There is another matter. If that is at 2 PM, then this will be 3 PM.
Deeply obliged, deeply obliged.
My lords, with regard to the appeal, let it be placed before the same honorable tribunal bench. My lord, Justice Tribunal.
We have changed it. We have changed. You
So
will
that is-
only, we have said that you will provide assistance to the tribunal for deciding the appeal.
Great.
This is what we have.
Tribunal decided by deformity.
I couldn't hear that. My lords, great.
My lord, in 306, my lord, the next matter. No,
Well,
not
that's
next matter. My lord, IA 2130 of 26, which your lordships had considered, my lord, when the application was handed over physically on 1/4, your lordships had passed an order stating that the IA be numbered and then placed before your lordships. Your lordships had considered the averments in the IA, and then your lordships had made it clear that if a counter affidavit has to be filed, let it be filed. My lord, the issue relates to, if your lordships kindly have a look at page 12 or page 11.
So that was in the earlier.
IA.
Well, this is 2021 post-poll violence.
No.
No, no,
Allegation.
my lords, that is
That
only
is what we were
2021.
referring
That
to.
is what the IA is.
And the reliefs that have been
Unless they're
prayed
now
for
changing their submission
are current
after filing the IA.
and real time. This is the reliefs that have been prayed for. It has been, they have referred to the post-poll violence that have taken place in 21 just to show that there is a real necessity for an interference now at this stage. And please have a look at, my lord, the reliefs prayed for at page 11.
Let's may please see the annexure. It is an inquiry report, NHRC.
The annex- That's because there has been,
12/7/2021.
that's because there has been a precedent of this happening in 2021. And that is when your lordships had remarked that please have a look at the statistics that we have extracted at page 6, 7, and 8. We don't want a repetition. Nobody wants a repetition. I don't think even the state government wants a repetition of what happened, what has happened in 2021 in the post-poll violence. What we have said, my lord, is that out of the, sorry.
Beg your lordship's pardon.
Try to respond to the IA.
Let them respond to the IA, my lord. They have not done it.
We will, my lords, whatever.
The matter
our
comes
we
up
will
next
respond
before
to
your
that one.
lordships.
Perhaps
They should have an affidavit, my lord.
the state,
Yes,
perhaps
we
the state.
The state and the ECI may look into these allegations and then give a response.
Yes.
As far as we are concerned, we will.
Yes.
And the
A
state
week's
government
time,
ought
my
to.
lords, we'll file a counter. We'll file a counter, 1 week's time.
उसमें पहले वाले order में लिखा with regard to the unnumbered IA
No, this is numbered now.
1216/2025 as referred to in para 1 of our order dated 1st April 2026, and senior counsel for ECI seeks and granted time to have instructions on 13th April. Mr. Naidu, just find out what.
Yes.
On 13th April 20.
My lords, the state will also like to file a
The
counter,
state
my
may
lords.
also file an affidavit in this regard.
Counter we'll file, my lords, 1 week's time, my lords, please.
Great.
Great.
Grateful, my lords.
Now, tell us what is the compliance that is.
Yes.
Well, as far as the NIA is concerned, my lord, our preliminary report is here. But we have done some inquiry. We've registered a PE, my lord. We want to take over the investigation. This honorable court may direct us to take over investigation of 3 FIRs which pertain to the judicial judges and 9 connected FIRs. Details are there in my. There are 3 incidents as far as judicial members are concerned. First is one lady judge was prevented from going to the venue where a separate FIR has been filed. The second FIR is with respect to the incident that of Gherao which took place at the venue itself. And the third incident.
The lady judicial officer was crying just now.
Yes.
Was
Prevented from going to the venue.
This incident was prior to this Gherao.
Same.
She was prevented from going to the venue and discharge her duties. She had to go back.
Inside.
Kindly have a look at my report, my lord. I mentioned the.
But I think
My lords are having the list of
can we have a copy?
FIRs, but I can't give you.
We are reading the affidavit of Sonia Singh.
That's, she's here. That was an affidavit of compliance, actually, that may be kindly ignored for the time being. But kindly have a look at annexure A, my lords.
That report.
Yes, report.
List A1 is the list, annexure A1 is the list of FIR.
Yes, my lords. Kindly have a look, my lords.
Where is that?
Now, first, my lords, may kindly have a look, my lord.
34.
Page 12, my lords, at paragraph 10, I've given a gist, my lords.
Paragraph 8 says.
9 and 10. my lords.
Summary here.
My lord has got
That
para 9
Motabadi,
of my report. Para 9 at the bottom, my lords. Registering of FIRs in relation to incident by local police, Roman 5, my lords. That would be page number 7 of my report. Bottom is the pagination, my lords.
no, you are starting,
May kindly have a look at, I'll start with page 7, my lord, of my report.
a registration of FIR in relation
Relating
to
to
a
incident by local police.
Hmm.
Hence, a total of 3 FIRs have been registered at so-and-so police station, district Malda, West Bengal on 2/4/2026 in connection with the incident directly involving learned judicial officers. My A is the first case, B is the second case, and my lord, C is the third case. These are directly involving judicial officers, 3 FIRs. And then, my lords, may kindly have a look at para 10. In addition to 3 FIRs registered in connection with the blockade attack on learned judicial officers, 9 other FIRs were also registered pertaining to blockades at various places in this area.
Where are you reading, Mr. Raju?
Page number 12. After I've extracted the gist of the 3 FIRs. But
In addition to these 3 FIR registered in connection with.
there are 9 other FIRs were also registered pertaining to blockades at various places in this area. List of such FIRs in annexure A. So there are total 12 FIRs which the NIA may be permitted to investigate.
How many people have been arrested?
Yes, Manoj, that chart is given, Manoj. 24 people have been arrested. But that, my lords, will find in the chart at page 17, my lord. Accused persons are 24. Identified troublemongers are 5. History sheeters are 24. Suspected person 9, B party members 309, and total of 432. CDR analysis is being, 432 persons are the persons whose CDR analysis we have requisitioned. Once we get the CDRs, we'll do the analysis, my lord, of the telephone data. But the problem is, my lord, the investigation is being carried out by the local police. This is not a scheduled offense where the NIA can directly take over unless, and therefore,
Mr. Raju, once we had directed.
my lords had directed an inquiry. They understood it was an inquiry/investigation. So they have conducted inquiry. Now they take over the investigation, my lord.
Absolutely, you must
And-
take over the investigation.
And the
Any
local-
person of local police leaving.
Local police may be directed to hand over the papers of investigation, case diary to us.
So these FIRs are lodged by the local police.
Yes. On second itself. This was before even NIA reached the spot. You want to say anything?
Now, if you come to page 21,
Yes, Manoj.
para 17, is it your inquiry?
Yes. Yeah, inquiry.
My lords are referring to page
Page
21.
21.
para 71, para 17.
Findings emerging thus from the inquiry.
Pre-incident developments.
Yes, ma'am. It is further emerged that prior to the, may I, since a copy has not been given, may I only, because this is investigation, I don't want the papers to go to the other side, my lords. But para 24 is about the lady judicial officer, my lords.
Writing is not a part of the scheduled offense?
No, my lords.
Writing
No, my lords. NIA, my lord, it doesn't.
does not have.
No. It, once we start investigation under section 8, we can take over connected offenses.
And immediately we are authorizing, we are passing order, you take over the investigation immediately.
Very good.
And why at serial number page 22,
Yes, ma'am.
para 20,
Yes, madam.
Roman 2, why this person be not arrested immediately? Because he is also, you will find out from him who are the persons who
Was instigating and was provoking them.
hired his services and
I told them yesterday itself that they must find out who this person is and probably arrest him also.
right now. So in deference to the order dated 2nd April 2024, passed by this court in so motu proceedings for his safety and security of judicial officers, deputed for work relating to SIR of electoral rolls in the state of West Bengal, we are informed that the Election Commission of India entrusted the inquiry to National Investigating Agency.
Yes.
NIA has consequently filed a preliminary
Status report.
status report in sealed cover, which has been opened. The contents of the report have been produced. We find that the FIRs mentioned therein were registered by the local police,
Yes.
by the state police. So since there are serious allegations against the members of the state stroke local police, we direct the NIA to take over investigation of these cases,
12 in all, my lords. 12 in all so far.
irrespective of the provisions under which FIRs have been registered. The
Irrespective of whether they're scheduled offense under the NIA Act.
Article 140.
Irrespective of whether
not
scheduled
happening,
offense
we
under the
direct-
NIA Act.
we in
Let me
exercise
turn
of-
to Article 140.
we in exercise of power under Article 142 of the
It was
Constitution
done even in Italian Marines.
directs that the investigation of these affairs be taken over by NIA, irrespective of the offences for which such FIRs have been registered. The NIA will also, the NIA will be at liberty to register further FIRs if during the course of investigation it is found that either more persons and FIRs, if it is found that the offences committed, the offences as illustratively referred to in our order dated 2nd April 2026 had other dimensions or
Connected
involvement of
offenses.
the persons for different considerations. We request the Honorable Chief Justice of the High Court at Calcutta. Is there any NIA designated court in Calcutta?
Yes, yes.
It's already there.
Special courts are all designated. There are 2 special courts.
So irrespective of the place of occurrence, the investigation report shall be submitted before the NIA court at Kolkata. Also, however, before filing of the charge sheet, the NIA shall continue to submit the status reports to this court,
Periodically.
giving details of the investigation carried out from time to time. the next report, further status report we filed on the date fixed, in the matter. Where are the,
Not just one thing.
Let's-
Hey, Lord, may I
Before
just
that,
take a
before
moment?
that, my lord,
May I just
let
take
the
a
local
moment?
police hand over the
Just for
papers.
completeness, Lord, I think one part.
Mr. Luthra, just one minute.
Sir, there are two
Mr.
of the
Luthra, just
main
1 minute.
conspirators were
My
arrested.
lord,
I'm
the
just-
local police may be directed to hand over the papers of investigation and the case diaries
draft will be taken
of
over
the
by
12 FIRs.
the state police stroke local, the state stroke local police directed to hand over
Immediately.
the entire record of
Immediately.
and the investigation to NIA forthwith. So the state police is further directed to provide any logistic support stroke assistance that may be required by NIA for taking the ongoing investigation to a logical conclusion.
May I just take?
May
a
I
moment?
give the names of the police stations, my lord? and
May I
the
just take-
list?
That's it.
I'll give the names and
Please give, then we'll mention those, that record of those.
status report. We can't give it in the list.
What is the report regarding this providing the adequate security, etc.? Mr. Naidu, are you filing?
Beg your lordship's pardon?
Who is filing the status report regarding the security?
Lord, may I just say that?
Well,
If I may,
the election commission is concerned, we have just handed over, and chief electoral officer, we have handed over. These are the two ones I've just handed.
Lord, may I just take a moment if my lord permits? But your lordship had asked us to file compliance reports. I represent the chief secretary and the DGP of the state. We have filed those and I'm carrying copies of those because they would not have come on record before your lordship, but they've been.
Whatever my lords have indicated minutes that we have complied with, that's placed with your lordship.
These copies, not I've got copies for your lordships. I must also point out, not since perhaps my learned friend may not be aware, Mr. Raju, that the two of the persons who were kingpins, and correct me if you would have had a copy of the affidavit, sir, which was filed by the DGP. I think the names are Mufakkarul Islam and Maulana Muhammad Shahjahan Ali Qadri. These two people were arrested.
No affidavit has been given to me. I'm sorry.
It has been e-filed, it's been supplied. NIA it may not have been because we
NIA is
didn't,
not- it's come-
NIA no, it's been given to the others. We'll give you a copy, sir. But they,
Rudra, whatever is the development of investigation with all the records, please hand it
No,
over.
no, I'm
and
saying
also
something
have a synergy with
my
NIA.
lord, there's no difficulty at all. All I'm saying is, those two people have been arrested. He can verify that. They were already arrested.
No, arrested by state police or?
Yes, by state police. Not that's, I've already put it on affidavit. And how many? 26, Lord, 26.
Are they in police custody or in judicial custody?
They're now, Lord, I'll have to,
They're in police.
I'll have to take instructions, Lord.
That is what happens unfortunately, because you arrest them and you don't.
Good as giving them
May I
protection.
just say this? May I just say this? Not the difficulty I have is,
Right
I've
down.
got this information, Lord, on,
It's all right.
worked overnight to give you a compliance affidavit.
Right down. The persons, the suspects who have been arrested so far by the state stroke local police and local police shall be independently interrogated by the NIA.
And taken on
And for
remand.
this purpose, their their custody shall be handed over
Lord, there
to NIA, even if meanwhile they have been sent to the judicial custody.
No, Lord, I've just got instruction, police
Caring
custody.
for the chief secretary, not the accused.
Sir, just a minute. Mr. Solicitor, I've been asked a question and you are not to intervene. Please sit, be patient. Lord, your lordship put a question to me. They're in police custody. I'm appearing.
Very fine. We are only
Verified,
saying
I've verified.
We are saying that even if they are in judicial custody.
Yes, of course.
Yeah.
No, I'm just pointing out that they are in police custody. I got that message right now, since your lordship put it to me.
It further seems that some of the suspects are still in police custody.
Yes.
Let their custody be also handed over to NIA.
Forthwith.
Forthwith. Now,
Lord, I represent, I've given the compliance affidavits, I'll tender them. Your lordship, they've already been submitted. There were two affidavits, your lordship already in compliance for the DGP and for the chief secretary, Lord. They are both here.
no, are they?
They are here, Lord, they're all here. Your lordship asked.
Mr. Chief Secretary, what is the problem? You don't even entertain the call of the Chief Justice.
Lord, I think he may have to be unmuted. Lord,
Milord, there was no call made by any officer from Calcutta to my phone. On 1st of April, I had come to Delhi for a meeting. And from 2 p.m. to 4:30 p.m., I was in flight. And till the evening, no call had come to me, Milord.
Mr. Chief Secretary, the phone calls in all probability came in the evening after you had deboarded from your flight to Delhi. It would have been extremely helpful for the Chief Justice and the High Court administration if you had been kind enough to share your mobile number and other particulars.
Milord, my mobile number had been shared, but that number didn't
That
have
number is mostly switched off, Mr. Chief Secretary.
Milord, that number is not mostly switched off, Milord. That number is more secure and its connectivity is better, Milord. That's why during the attendance.
So high that the Chief Justice of Calcutta High Court or the High Court administration cannot access. So please lower yourself a bit so that ordinary minions like the Chief Justice of the Calcutta High Court can access it.
At least we can have an access to the
Chief Justice or the Chief Secretary.
Milord, I'm extremely apologetic regarding this miscommunication. I didn't
Please
have
write a letter of apology to the Chief Justice of the Calcutta High Court.
This if you don't expect at least from the Chief Secretary that you refuse to acknowledge the Chief Justice of the High Court to whom for no reason, and it's only because of sheer failure of your civil administration, your person sitting on your side, the police administration. It is sheer failure of both of you and your administration that we gave this authority to the judicial officer.
And because of your lack of communication, the Election Commission of India is kept in the dark. You don't communicate either with the High Court administration, neither do you communicate with the Election Commission of India, which is entrusted with giving directions to you in cases of emergency like this. And this missing link creates so much of difficulty and disturbance in the state.
Lord, if I may, on 2nd, he was before the Election Commission in Delhi.
We are aware of the fact that
He
you
does
have
not
been
pick up
recently
the phone.
posted.
His
That is not
phone
the
is
point.
inaccessible.
The of your institution,
I'll respond to that.
Office of the Director General of Police, the Office of the Chief Secretary. What kind of credibility this West Bengal bureaucracy has brought to this? Why the entire state is seen as if the politics is being played even in the secretariat or in offices? Please help in improving that image and do something, whatever being appropriate at least at this stage. We really don't want to take it. It is not something that senior most officers should invite the adverse comments or any penal action from us.
Milord.
We don't enjoy and we don't like this kind of undesirable or avoidable kind of orders. But if you compel us, then of course we have to perform our duty.
Milord.
In fact, Lord, I must say both they were pointed on
The
16th
advocate,
March.
the Director General of Police, 11:30, the Chief Justice is telling me on phone that
There is a limit to
waiting for the
inaccessibility.
Director General of Police to arrive at his
They informed, the Honorable Chief Justice was informed.
Lord,
That for
I may say-
hours on end,
I may
efforts
say
were
so.
made to
No, Lord.
get access to
I
the
may
Chief
say so, Lord.
Secretary. Even the Home Secretary is unable to
Yes, no,
contact the
Lord,
Chief
Lord, may I
Secretary.
just say this, Lord, there's a WhatsApp group, in
The-
fact,
Mr. Luthra, please don't defend this.
I'm not defending, Lord, I'm just telling you.
Like a very strong, obstinate character of bureaucracy, and it is not in this state because now there is a lot of turmoil that we are facing it. In other states also the things are not good.
I understand.
The way they are being pampered, unfortunately.
What has fallen from my Lord Justice Bagchi is not something is very clear, Lord. It'll be
Please, whatever way you at least have a word of apology before the Chief Justice and try to redeem what you have done
It'll be
in the
done.
past.
It'll be done. It'll be done, Lord. That's.
See, in
But all the officers are here, Lord.
in compliance to the order dated, in compliance to para 13, in bracket Roman 7, the Chief Secretary and Director General of Police are present online. They have submitted their explanation affidavit also, which are taken on report. We hope that they have realized the we hope and trust that both the officers have now well understood the sense of responsibility and the manner in which they ought to have, they were expected to respond and provide assistance to Honorable Chief Justice of the High Court when 7 judicial officers were made hostages on 1st April 2026. Subject to the report that may be sent by Honorable Chief Justice of the High Court, we do not propose any further action against the officers to whom notices were issued by the above mentioned order.
Grateful, Lord. Lord, the district magistrate and the SP are also online.
We have direct the Chief Secretary, Former Director General of Police, and the entire police, civil and police administration of State of West Bengal to extend full assistance and support to the
Election Commission.
to Honorable Chief Justice of the High Court till the entire process of SIR is complete or the appeals by the appellate tribunals are decided.
Lord, the DM
not
and
much-
the SP are also here, my lord.
Yeah,
The
DM and
DM and the SP are also here, my lord. They were present, my lord, for most of the time, my lord, managing the
They
city.
were watching. They were watching.
Like-
They were watching. Mr. Gupta, you don't know the situation. When the registry contacted the SP, he said that what can I do? Women are there. You asked me, we will be killing the women. This is the degree of awareness of intelligence in the district. This is the extent of their responsibility in maintaining law and order.
Commissioner of
What to
Police,
say?
Yes.
Commissioner of Police was not there at 11 PM, around 11, maybe around 11:30 PM. The Chief Justice informed me that he is on his way to there, 11:30 PM. Director General of Police was on his way to go to the Chief Justice. The incident had started taking place at 3:30 PM. By 11:30 PM, you can imagine what must have happened, and it can be seen from the photographs and the video clip we are seeing it.
Mr. Gupta,
Hundreds of people were allowed to
it was
assemble there.
only because of the timely intervention of the Honorable Chief Justice of India, something very unfortunate or untoward was avoided.
Very true.
Yes, yes. We are really grateful, my lord, as a,
For the intervention.
yes, for the intervention of your lord.
Great.
We'll take upon, then we'll see, that because they are ongoing.
Yes, my lord's
process,
convening.
Because we need to now assistance of NIA from at least for
Yes.
identifying these persons. And we take upon 13th for the timing, but if your investigation is still going on, you need not to submit any report. You can submit only one page saying that it is going on, there is nothing worth a status report. That is good enough for us. But you keep on, and because by that time, if you face any bottleneck or any, at least we will be able to resolve for you in case any need
I
arises.
request for Friday, my lord, in that case.
So 13th is fixed already.
13th.
There is one matter fixed at 30, my lord, but we are before the Chief Justice here too.
13th
The other
already
matter
fixed.
13, that's why we are
13.
keeping it on.
Yes, Lord.
Very well.
Otherwise, we know that it's very short time and it may not, but there is no such pressure from our side that you do it. And there is nothing to be done in hurry also. You take your time, identify the person, because it doesn't.
You've already
seems
done,
to be some calculated move. It was not an ordinary emotional reaction by the people. It was definitely a motivated, a pre-planned, and something deeply instigated.
Concerted.
So you please identify those persons. We also want to take them to a logical conclusion.
Page 19,
We
we've
will not allow
identified
this
as
thing to
some-
happen.
Great.
But we're deeply obliged, not ungrateful. Deeply obliged and grateful, I said.
That's it. Thank you very much. Thank you.
Great.
Hello, everyone. So those who have been with us all for the past 2 hours, it is time for us to do a quick recap as what transpired in the Supreme Court today. And as we do that, dividing ourselves between 2 channels, one which is in English and another one in Bengali, we will try and be as bilingual as possible. We will try and do this recapping both in English and Bengali. To begin with, today's Supreme Court hearing can be divided in 3 very important categories. Category number 1, which is SIR. Category number 2, the tribunal, the disposal of cases, and what happens to those who are deleted, now seeking redressal from the tribunal. Will they be allowed to cast their vote or not? And category number 3, as what happened in Malda with 7 judicial officers who were almost kept ambushed, and I would use that word very consciously, who were kept ambushed for almost 7 hours and more. The state national highway, the state highway in fact, was also under the siege of protesters for good 12 hours. So all of that today was discussed and today deliberated, and there are 2 specific interim orders in that effect. What is the case in hand first? The case in hand first was the SIR hearing, and the SIR hearing has laid open couple of very important aspects. Number 1, there were about 57 lakh cases which are already disposed of, all right, which were under adjudication. 57 lakh cases have already been disposed of. Now, the Chief Justice's bench did ask as how long will it take to dispose of rest of the cases. The assurance which has been given by the Election Commission of India, the rest of the cases would be disposed of today itself. All right. So that is point number 1. Takeaway number 1. There were about 60 lakh plus cases which were put under adjudication, and today Justice Joy Mallo Bagchi used another word very consciously. He said not adjudication but verification, because the judicial officers were essentially verifying documents which were there as a case file pertaining to each person put under doubt or put under logical discrepancy. So essentially, all these cases which eventually went to the judicial officers, today out of 60 lakh plus cases, the Election Commission of India has communicated to the bench of Chief Justice of India that about 57 or 58 lakh cases have already been disposed of, and rest of the cases, going by the speed that it has maintained, will be disposed of today itself. Point number 2, those who have been disposed of, how many people have been sent back to the voter list and how many people have been shown deleted? Out of 60 lakhs, the record which is available with the with the petitioners, that roughly about 47 lakh cases have been disposed of, out of which senior advocate Diwan, representing Mamata Banerjee's petition, he categorically stated that about 44% cases have been deleted, that is the rate of rejection, and 45% cases have been sent back, which is the rate of acceptance. Now, if you go by the number 44% out of 47 lakhs, the number stands roughly about 20 lakh cases have been deleted. 20 lakh people have been shown deleted after adjudication at the hands of the judicial officers. Now, out of those 20 lakh cases, about 7 lakh cases, about 7 lakh appeals have now been filed for further hearing before the tribunal. All right. Now, there will be more cases filed for more hearings. Here is the big catch. Those who are filing their cases for hearing before a tribunal, what happens to them? If all 20 lakh people file their cases for hearing before the tribunal, that would be headed by 19 judges, including former chief justices, what happens to them? And can all those 20 lakh cases, if they are filed before the tribunal, can they all be disposed of within a stipulated time? Is that possible? If not, will they be able to cast their vote this election? These are all fundamental questions which found a mention today. It was also proposed by Senior Advocate Diwan that let's keep a cutoff date, say 15th of April, because first phase of polling happens on 23rd of April. By 15th of April, those who have been disposed of at the hands of the tribunal and those who make it back to the voting list, they should be considered in the final voter list, number one, so that they get to cast their vote, in Bengal election 2026. What was the other proposal by Mamata Banerjee's advocate? That those whose matter would still be sub judice, those whose matters are not being disposed of as yet at the hands of the tribunal after they having filed an appeal, out of them who are already mapped with the 2002 voter list, they may be considered the right to vote in this election. Now, is that possible? Will that happen? While the bench of Chief Justice of India, along with Justice Joymal Bakshi, did not confirm a yes or a no, but the observations highlighted by Justice Bakshi indicate that they have got strong reservations. Why? According to Justice Joymal Bakshi, that look, there are Form 6 coming in, and we have a strong reservation in not having a cutoff date for Form 6 applications be accepted, which means new voters. If final list has come out on 28th of February, and if we consider that as a cutoff date, then further Form 6 applications and acceptance of them may vitiate the trust and the transparency the final voter list is trying to exude post SIR exercise, right? So if we are trying to keep a cutoff date for Form 6 acceptance, why can't and why shouldn't there also be a cutoff date for why should there not be a cutoff date for the adjudication process? Even after adjudication, if cases are now if people make it back to the voter list, it would only go on kind of niddling the final voter list, and that has to be frozen at some point or another. So the submission which has gone before the bench time and again by the petitioner, that is Mamata Banerjee, that those who are mapped by 2002 voter list, even if their cases stay under trial before the tribunal, let them be given a chance to cast their votes in this election. There is no clarity if that would be possible. But what clarity we have, the Election Commission of India had vociferously objected to that. Election Commission of India kept on insisting and highlighting the very fact that, look, the judges have been more than accommodating. The judges initially wanted the matter to be disposed of at the judicial officers level. Now they have further extended it to tribunal, so that the matter can eventually so if somebody wants to seek redressal, they can, but that is all for the future and not for immediate election, right? Because according to Election Commission of India, it is absolutely fine for voters who are valid not be given the fundamental right to vote. I'm like, we are amazed. The way Election Commission of India had vociferously objected to this very fact that those who are making it back to the voter list, they should be given a chance to cast their vote this election. And those who are already mapped with 2002 voter list, even if their cases are under trial, they should be allowed to cast their vote principally because they're mapped. To which the Election Commission of India had very, very strongly, vociferously objected and said that is not possible. This entire tribunal exercise, it is for the future, so that those who are seeking redressal, they can seek redressal, and if they are valid, they get the vital constitutional right to cast their votes, but in future. So if somebody who is a valid voter, who had been denied the right, who has been disenfranchised by the Election Commission of India because of logical discrepancies, which have nothing but been a reflection of all whims and fancies, then in that case, instead of accountability being fixed on the Election Commission of India, why is it that the Election Commission of India is hell-bent in ensuring that those who have been deleted now, let them find their redressal later, let them come back to the voter list later, but let them not cast their vote this election? Why is it so important for Election Commission of India to restrict valid voters who have been disenfranchised by Election Commission of India, which itself is being challenged before the Supreme Court, which itself is getting challenged before the trial, that they are so hell-bent, so keen in not allowing them to cast their votes this election? What is the modus operandi? What is the motive behind it? So there is a high possibility, going by what you have seen, going by what you have heard, there is a high possibility that probably whose votes, okay, so probably those who have been disenfranchised for now, even if they are moving for redressal before the tribunal possibly will not have a pressure of being under time bound. They may take 60 days, they may take more, as being suggested by the Supreme Court. And in a situation like that, the possibility is those who are seeking redressal, even if they happen to be a valid voter, even if their votes if their voting rights gets validated by the tribunal, they probably will come back to the voter list of Bengal for future election, but not for Bengal election 2026. Let's hear the proposal made by Senior Advocate Shyam Devan and the suggestions made before the bench. The conversation thereafter that happened between Justice Joy Malabakshi and Senior Advocate Shyam Devan. Listen in.
Cases, available data of 44 lakhs cases indicates that the inclusion rate is about 55%, which is 24 lakhs, and the exclusion rate is 45%, which is 20 lakhs. The rejection rate appears to be very high despite the judicial safeguards. This is keeping in mind, Millard, that these are all mapped individuals. Now, para 4. Out of the 20 lakh published cases of deleted electors, almost 7 lakhs have already filed and several lakh appeals are in the process of being filed. This is our understanding. This court notified the appellate tribunal on the 10th of March. However, the appellate tribunals are yet to be fully operationalized. What we mean by this is functioning in, just as the judicial officers were, because there were some hiccups, etc. Very few appeals were taken up by the 19 appellate tribunals so far. That's our information. Now, this is a cause of concern, my lords. B, there are long meandering queues formed outside offline filing facilities, and electors are opposed with great difficulty for filing an appeal promptly. There are news reports, my lords, we've given some photographs, very lengthy. Yes, on the second page, your lordships will see, for example, lengthy queues are developing over here just for filing of these appeals. Para 6, in the first phase of elections in West Bengal, in respect of 152 assembly constituencies, the last date for filing is 6th of April 2026. The polling day for this phase is 23rd April 2026. For the second phase, the dates are 9th April and 29th April.
শুনলেন সিনিয়র অ্যাডভোকেট শ্যাম দেওয়ানকে। এবার আমি বাংলায় অনুবাদ করব আজকে সুপ্রিম কোর্টে যেটা হয়েছে। অনেক দর্শক বন্ধুরা আমাদের বলেছেন এবার বাংলায় বলবার জন্য, যেমনটি বলেছি দুটো চ্যানেলে লাইভ স্ট্রিমিং হচ্ছে বলে আমাকে জাগল করতে হবে ইংলিশ এবং বাংলার মধ্যে। আশা করি আপনারা ধৈর্য রাখবেন, আশা করি আমাদের সঙ্গে সহযোগিতা করবেন। আজকে সুপ্রিম কোর্টের হিয়ারিং কে 3 ভাগে ভাগ করা অতি সহজ। প্রথম ভাগ কি এসআইআর, দ্বিতীয় ভাগ কি যারা ট্রাইব্যুনালে যাবে তারা কি নিজেদের ভোটিং রাইট সেটাকে অক্ষত রাখতে পারবে, তারা কি ভোট দিতে পারবে, সক্ষম হবে, এটা হচ্ছে দ্বিতীয় পার্ট। এবং 3 নম্বর পার্ট হচ্ছে মালদাতে যে দুঃখজনক ঘটনা ঘটেছে যেখানে জুডিশিয়াল অফিসারদেরকে 7 থেকে 10 ঘন্টার মতো ঘেরাও করে রাখে এবং পথ অবরুদ্ধ রাখে, যে ম্যাটারটা ইভেন্চুয়ালি এনআই ইনভেস্টিগেট করছে। এটা হচ্ছে ফ্যাক্টর নাম্বার 3। যদি আমরা প্রথমে এসআইআর নিয়ে আলোচনা করি, এসআইআর এর আলোচনার আজকে কয়েকটা ভীষণ গুরুত্বপূর্ণ জিনিস সামনে এসছে। এসআইআর আলোচনার কয়েকটা জিনিস আজকে খুব গুরুত্বপূর্ণ জিনিস সামনে এসছে। 1 নম্বর, যেই ম্যাটারগুলো জুডিশিয়াল অফিসারদের কাছে গেছে লজিক্যাল ডিসক্রিপেন্সির নামে, তাদের সংখ্যাটা কি? সুপ্রিম কোর্টকে আজকে ইলেকশন কমিশন জানিয়েছেন যে 60 লক্ষ যে কেস ছিল, 60 লক্ষের মধ্যে 57 থেকে 58 লক্ষ কেস অলরেডি ডিসপোজ অফ হয়ে গেছে এবং যেটা পড়ে রয়েছে, যেই বাচনটিটা পড়ে রয়েছে সেটা আজকের মধ্যে নিষ্পত্তি হয়ে যাবে। অর্থাৎ জুডিশিয়াল অফিসারদের হাতে যেই কেসগুলো গেছিল অ্যাডজুডিকেশনের জন্য লজিক্যাল ডিসক্রিপেন্সির তালিকায়, সেই সকল ম্যাটার আজকের মধ্যে নিষ্পত্তি হয়ে যাওয়ার সম্ভাবনা রয়েছে। ইলেকশন কমিশন অফ ইন্ডিয়া এমনটাই জানিয়েছেন সুপ্রিম কোর্টকে। পয়েন্ট নাম্বার 1। পয়েন্ট নাম্বার 2, সিনিয়র অ্যাডভোকেট শ্যাম দেওয়ান যিনি মমতা ব্যানার্জিকে রিপ্রেজেন্ট করছেন, উনি একটা অঙ্ক রেখেছেন। কি বলেছেন? যে তাদের কাছে যে অঙ্কটা আছে সেই অঙ্কটা বলছে 47 লক্ষের মতো কেস নিষ্পত্তি হয়ে গেছে। হয়তো তার কাছে যে অঙ্কটা আসছে সেটা কালকের, আর আজকে সুপ্রিম কোর্টে যে অঙ্কটা গেছে ওটা আজকের ইমিডিয়েট অঙ্ক। তো আজকে শ্যাম দেওয়ান যেটা বলছেন সিনিয়র অ্যাডভোকেট, যে আমাদের কাছে যে ডেটাটা আছে সেই ডেটা অনুযায়ী 45% অ্যাকসেপ্টেন্স রেট, অর্থাৎ 45% মানুষ 47 লক্ষের মধ্যে তাদেরকে আবার অ্যাকসেপ্ট করে নেওয়া হয়েছে ভোটিং লিস্টে, রাইট? তারা এবার ফেরত যাচ্ছে ফাইনাল ভোটার লিস্টে। যারা এবার ফাইনাল ভোটার লিস্টে ফেরত যাচ্ছে তারা সম্ভবত ভোট দিতে পারবে, রাইট? এবার 44% হচ্ছে রিজেকশন রেট, অর্থাৎ 47 লক্ষের মানুষের মধ্যে নানা করে 20 লক্ষ মানুষকে অলরেডি ডিলিট শো করা হয়েছে। মনে রাখবেন সম্পূর্ণ অঙ্কটা কিন্তু 60 লক্ষ সামথিং। তার মধ্যে আজকে ইলেকশন কমিশন বলেছেন 58 লক্ষ মতো কেস নিষ্পত্তি করে দেওয়া হয়েছে, কিন্তু মমতা ব্যানার্জির অ্যাডভোকেট সিনিয়র অ্যাডভোকেট শ্যাম দেওয়ানের কাছে যে ডেটাটা আছে সেটা হচ্ছে 47 লক্ষের। তাই 47 লক্ষের মধ্যে যদি 44% মানুষকে ডিলিট করে দেওয়া হয়, অর্থাৎ 20 লক্ষেরও বেশি মানুষকে ডিলিট করা হয়েছে। এবারে 20 লক্ষ মানুষের ভবিষ্যৎটা কি? এই 20 লক্ষ মানুষের জন্যই কিন্তু ট্রাইব্যুনাল করা হয়েছে, যেখানে তারা সশরীরে উপস্থিত থেকে আপিল করবার পর, যেমন কোর্টে হিয়ারিং হয়, আপিল করবার পর আপনি যখন কোর্টের আপিলের জন্য অ্যাপ্লিকেশন ফাইল করেন তারপর অ্যাপ্লিকেশনটা কোর্টে যায়, কোর্টে জাজেদের কাছে যায়, ঠিক তেমনি এখানে আপনি এই ডিলিশনের বিরোধিতা করে চ্যালেঞ্জ করে আপনি যদি অ্যাপিল ফাইল করেন, সেই অ্যাপিলটা যখন ট্রাইব্যুনালে যাবে তখন আপনাকে হিয়ারিং করা হবে, আপনাকে শোনার একটা সুযোগ আসবে জাজেসদের কাছে। কজন জাজ আছেন? 19 জন জাজ আছেন। সব থেকে বড় প্রশ্ন, ট্রাইব্যুনাল কি এখন অব্দি শুরু হয়েছে? ইলেকশন কমিশন অফ ইন্ডিয়া বলছেন যে এখন অব্দি শুরু হয়েছে, এক দুটো কেস করে নিয়েছে, সম্পূর্ণরূপে অপারেশনাল একদম হয়ে যাব। যে একই জিনিস আগের বারও আমরা শুনেছিলাম 1 সপ্তাহ আগে। 10ই মার্চ থেকে ট্রাইব্যুনাল অপারেশনাল হওয়ার কথা ছিল। আজকে ইলেকশন কমিশন অফ ইন্ডিয়া বলছেন বেহালা জোকায় যেই জায়গাটাকে আইডেন্টিফাই করা হয়েছে, যেখানে বেঞ্চ টেবিল কম্পিউটার লাগানোর কথা, সেই জায়গাটা মোরালেস পুরো রেডি হয়ে গেছে, এবার আমরা রেডি, এবার আমরা কাজ শুরু করব। তো এবার যদি ইলেকশন কমিশন অফ ইন্ডিয়ার প্রস্তুতি সম্পূর্ণ হয়, এবার জাজেরা গিয়ে, জাজেদের তো দোষ নেই, জাজেরা যখন নিজেদের ইনফ্রাস্ট্রাকচার পাবেন তখন গিয়ে তারা কাজ করতে পারবেন। ইনফ্রাস্ট্রাকচার দেওয়ার কাজ ছিল ইলেকশন কমিশন অফ ইন্ডিয়ার। ইলেকশন কমিশন অফ ইন্ডিয়া 10ই মার্চ থেকে নিয়ে আজকে অবধি ট্রাইব্যুনালের সম্পূর্ণ যে একটা সেট আপ সেটা রেডি করতে পারেনি। আজকে কত তারিখে আমরা দাঁড়িয়ে রয়েছি? আমরা দাঁড়িয়ে রয়েছি এপ্রিল মাসের 6 তারিখে, রাইট? এপ্রিল মাসের 6 তারিখে আমরা দাঁড়িয়ে রয়েছি। যদি ইলেকশন কমিশন অফ ইন্ডিয়া জোর গলায় বলে যে দেখুন আমাদের কাজে কোনো ভুল ত্রুটি নেই, আমরা সব ভালো করেছি, আর এই ট্রাইব্যুনালের এক্সারসাইজটা পুরোপুরি ওয়েস্ট অফ টাইম, এতে বেশি কিছু হবে না, মাইক্রো অবজারভাররা যা করেছিল সেটা দারুণ কাজ করেছিল, জুডিশিয়াল অফিসাররা যা করেছে সেটাও খুব দারুণ কাজ, এরপরে ট্রাইব্যুনালের কাজের আর কোনো গুরুত্ব নেই। কেন জানেন এটা ইলেকশন কমিশন অফ ইন্ডিয়া বলতে পারবে না? এই জন্য বলতে পারবে না কারণ কংগ্রেসের প্রার্থী যার নাম মেহতাব শেখ, যাকে ইলেকশন কমিশন অফ ইন্ডিয়া ডিলিট করে দিয়েছিল, তাকে ট্রাইব্যুনাল বৈধ ভোটার হিসেবে আবারও এস্টাবলিশ করলো, রিইনস্টেট করে দিল। ইলেকশন কমিশন অফ ইন্ডিয়ার কাজ, যেটা মাইক্রো অবজারভার দ্বারা ফ্যাসিলিটেটেড, যেটা মাইক্রো অবজারভাররা ফ্যাসিলিটেট করে জুডিশিয়াল অফিসারদের কাছে গিয়েছিল, যেই মানুষটিকে ইলেকশন কমিশন অফ ইন্ডিয়া ডিলিট করে দিয়েছিল, যিনি কংগ্রেসের প্রার্থী, তাকে ডিলিট করে দিয়েছিল, সেই প্রার্থীর ম্যাটার যখন ট্রাইব্যুনালে তৎপরতার সঙ্গে যায়, এক্সপিডিশিয়াসলি যায়, তখন ইলেকশন কমিশন অফ ইন্ডিয়ার ডিসিশনকে রিভার্স করে দিল জজ। অর্থাৎ ইলেকশন কমিশন অফ ইন্ডিয়ার কাজে যে ভুল ত্রুটি আছে বা থাকতে পারে সেটা নিয়ে কোনো সন্দেহ নেই। আজকে কংগ্রেসের প্রার্থী যার নাম হচ্ছে মেহতাব শেখ, তিনি একজন মুসলমান, তাকে যখন ডিলিট করা হয়েছে তাকে নিশ্চয়ই অনেক কটূক্তি শুনতে হয়েছে, এই তুই তাহলে রোহিঙ্গিয়া, ওই তুই তাহলে ঘুষপেটিয়া, বলেছে তো সমস্ত রাজনৈতিক মঞ্চে আমরা শুনেছি, পার্টিকুলারলি একটি পলিটিক্যাল পার্টি, যে ঘুষপেটিয়াদেরকে ডিলিট করা হবে আর রোহিঙ্গিয়াদের ডিলিট করা হবে। ইনি কংগ্রেসের ক্যান্ডিডেট যাকে ডিলিট করা হয়েছিল, ইনসিডেন্টালি উনিও মুসলমান। ইলেকশন কমিশন অফ ইন্ডিয়ার ডিসিশনকে রিভার্স করে দিল ট্রাইব্যুনাল। অর্থাৎ ট্রাইব্যুনালও ইলেকশন কমিশন অফ ইন্ডিয়ার কাজে ভুল ত্রুটি পেয়েছে, রাইট? ট্রাইব্যুনালে যে বাকিদের নিষ্পত্তি হওয়ারও সম্ভাবনা আছে সেটা ভুলে গেলে চলবে না। যেই 20 লক্ষ কেস বা 25 লক্ষ কেস বা যত কেসই যাবে, সেটা যে ট্রাইব্যুনালে গিয়ে তার নিষ্পত্তি হতে পারে, তার একটা বিশাল বড় সম্ভাবনা থেকে যায়। এবার আসি সব থেকে ইম্পর্টেন্ট প্রশ্নের, যারা আজকের তারিখে ফেরত এসে গেছে ভোটার লিস্টে তারা ভোট দিতে পারবে। যারা এবার ট্রাইব্যুনালে যাবে, 7 লক্ষ কেস অলরেডি ফাইল করা হয়ে গেছে, আপিল ফাইল করা হয়ে গেছে। এই যে এবার বাকি যে কেসগুলো রয়েছে, তারা যদি আপিল করতে চায়, তাদের আপিল করবার রাস্তাটা কি? একটা হচ্ছে অনলাইন, আরেকটা হচ্ছে অফলাইন। সুপ্রিম কোর্টের আজকে আলোচনার মধ্যে এটাও সামনে এসছে, আরে অফলাইনে তো খরচা হতে পারে, আসো যাও, অনলাইন করো। আমরা নিশ্চয়ই ডিজিটাল ইন্ডিয়াতে বাস করি, কিন্তু এই ডিজিটাল ইন্ডিয়াতেও নিশ্চয়ই ডিজিটাল ফ্রড হয়। আর ডিজিটাল ফ্রড এই জন্যই হয় কারণ ডিজিটাল লিটারেসি যদি সবার 100% হতো, তাহলে ডিজিটাল ফ্রড নিশ্চয়ই হতো না। ডিজিটাল ফ্রড এই জন্যই হয় কারণ ডিজিটাল লিটারেসির যে গ্রাফ, সেটা এই তলানি থেকে এত উপরে, আবার নিচে এরকম একটা ইউনিফর্ম নলেজ, এক্সপিরিয়েন্স, উইজডম নেই। তাই যাদের কাছ থেকে এই জিনিসটা কাম্য করা হচ্ছে, মনে করুন মুর্শিদাবাদের একটা প্রত্যন্ত গ্রাম, সেখানে ওই এখনো ছোট ফোনে কথা বলেন কেউ, তাকে ডিলিট করে দেওয়া হয়েছে, তিনি কি করে অনলাইন ফাইল করবেন? অনলাইন ফাইল করবার জন্য আপনার তো একটা স্মার্টফোন চাই। এই স্মার্টফোনে গিয়ে আপনাকে লগ ইন করতে হবে ইলেকশন কমিশনের ওয়েবসাইটে, রাইট? তো এই যোগ্যতাটা কি সবার কাছে আছে? এই পার্টিকুলার আর্গুমেন্টটা আজকে আসে। আপিলের জন্য অনেকগুলো জায়গা আছে যেটা ইলেকশন কমিশনের দ্বারাই অলরেডি নমিনেটেড, ডিএম অফিস, বিডিও, এইসব জায়গায় গিয়ে ফিজিক্যাল আপিল গুলো আপনি করতে পারেন। আপনাকে ডিলিট করে দেওয়া হয়েছে, জুডিশিয়াল অফিসারদের হাতে যখন অ্যাডজুডিকেট করা হয়েছিল আপনাকে ডিলিট করে দেওয়া হয়েছে। এবার আপনি ফেরত যাচ্ছেন নিজের আপিল নিয়ে ওই ডিসিশনটাকে চ্যালেঞ্জ করতে। ভেরি গুড, আপনি গেলেন, কিন্তু আপনি যাবেনটা কোথায় সেটা অলরেডি ইলেকশন কমিশন বলে দিয়েছে। যদি আপনি অনলাইন না করেন, আপনাকে যেতে হবে ডিএম এর অফিসে, বিডিওর অফিসে, যেটা ইলেকশন কমিশন ডিসাইডেড। যেই জায়গাটা একটা ধোঁয়াশা ছিল, আপনি মনে করুন গেলেন, কাগজপত্র জমা দিলেন, আপনি যে গেছেন কাগজপত্র জমা দিয়েছেন তার প্রমাণ তো আপনার কাছে একটা থাকা উচিত। সবাই আমরা ব্যাংকে যাই, ব্যাংকে গিয়ে নিজের অ্যাকাউন্টে টাকা জমা দেওয়ার অভিজ্ঞতা সবার আছে। তাই যখন আপনি ব্যাংকে টাকা জমা দেন, আপনি একটা ছোট্ট ফর্ম ভরেন, যখন কাউন্টারটা আপনাকে দেয় ওর মধ্যে স্ট্যাম্প মেরে দিয়ে দেয়, বা চেকও যখন জমা দেন, চেকের ওই ফর্মটা একটা ছোট্ট কাউন্টার আপনাকে দিয়ে দেয়। এটা হচ্ছে প্রমাণ যে আপনি ব্যাংকে গিয়ে চেকটা ড্রপ করেছেন বা আপনি ব্যাংকে গিয়ে এই টাকাটা জমা দিয়েছেন। ঠিক তেমনি এরকম প্রমাণ মানুষের কাছেও থাকা প্রয়োজন, কারণ একটা অবিশ্বাসের পরিস্থিতি রয়েছে। ইলেকশন কমিশন বলতে পারে কালকে যে এরা তো আসেইনি, মানুষগুলো বলতে পারে আমরা গেছিলাম, আমাদেরকে ইচ্ছে করে ডিলিট করে দেওয়া হচ্ছে। তাই আজকে সুপ্রিম কোর্ট বলেছেন যে যেখানে যেখানে ফর্মগুলো অফলাইনে জমা দেওয়া হবে, মানে কারোর কাছে গিয়ে দপ্তরে গিয়ে জমা দেওয়া হলো, সেখানে আপনাকে একটা রিসিট দিয়ে দেবে, আপনি সেই রিসিটটা পেয়ে যাবেন, রাইট? আর অনলাইন যখন আপনি করছেন তখন তো আপনি রিসিট পাবেনই পাবেন। এই গেল পয়েন্ট নাম্বার 2। পয়েন্ট নাম্বার 3, যারা এখন অ্যাপ্লিকেশন ফাইল করবে ট্রাইব্যুনালের কাছে, ট্রাইব্যুনাল অব্দি পৌঁছে তো আপনার সময় লাগবে। আমরা দাঁড়িয়ে রয়েছি 6 এপ্রিলে। এবার ফাইনালি মনে করুন আরো দিন 2-3 দিনের মধ্যে আপনি জানতে পারলেন যে আপনাকে ডিলিট করে দেওয়া হয়েছে। এবার আপিল করতে করতে তো আপনার সময় লাগবে, রাইট? তো ফাইনালি আপনার ট্রায়ালটা ট্রাইব্যুনালে কি ইলেকশনের আগে শেষ হবে কি হবে না, এটা নিয়ে একটা বিশাল ধোঁয়াশা রয়েছে। আজকে মমতা ব্যানার্জির যে অ্যাডভোকেট, উনি সিনিয়র অ্যাডভোকেট ধওয়ান, উনি বারবার করে বললেন একটা জিনিস, যে দেখুন যারা ট্রায়ালে যাবে, যাদের ম্যাটারটা অলরেডি ডিসপোজ অফ হয়ে যাবে, মনে করুন 20 লাখের মধ্যে বা 10 লাখের মধ্যে 10 জনের নিষ্পত্তি হয়ে গেল, সেই মানুষগুলোকে আবার ফাইনালি ভোটার লিস্টে ফেরত এনে ভোট দেওয়ার অধিকারটা তাদের দেওয়া উচিত, রাইট? 1, 2, যাদের নিষ্পত্তি হলো না, ইলেকশন চলে এলো, তাদের মধ্যেও একটা ক্যাটেগরি আইডেন্টিফাই করা উচিত। কোন ক্যাটেগরি? যারা অলরেডি 2002 এর সঙ্গে ম্যাপ, যারা 2002 এর সঙ্গে ম্যাপ কিন্তু ডিলিট হয়ে গেছে, তারপর ট্রায়ালে গেছে, আর ট্রায়াল চলছে, ইলেকশন এসে গেছে, সেই সকল মানুষগুলোকে অ্যাজ আ বেনিফিট অফ ডাউট তাদেরকে আবার ভোটিং লিস্টে ফেরত এনে তাদের ভোট দেওয়ার অধিকার দেওয়া উচিত। ইলেকশন কমিশন অফ ইন্ডিয়া কি বলেছে সেটা তো নিশ্চয়ই দেখাবো, কিন্তু সুপ্রিম কোর্টের জাজেদের মধ্যেও একটা জড়তা অনুভব করা গেল যে যদি আমরা ফর্ম 6 এর ইনক্লুশনের একটা কাট অফ ডেট রাখতে পারি, ঠিক তেমনি যারা ডিলিট হয়ে গেছে তাদের আবার ফাইনাল ভোটার লিস্টে ফেরত আনবারও একটা কাট অফ ডেট রাখতে হবে, রাইট? আমি কাট অফ ডেট ছাড়া চললে একটা হচপচ খিচুড়ি হয়ে যাবে। আমরা মানি যে মানুষের একটা গণতান্ত্রিক অধিকার আছে এবং সেটা বজায় রাখা খুব ইম্পর্টেন্ট। হ্যাভিং সেড দ্যাট এই যে ট্রাইব্যুনালের কাছে যে কেসটা আসছে, তাদের উপর অযথা প্রেশার ক্রিয়েট করা যেতে পারে না যে তোমার কাছে 19 জন জাজের কাছে আমি 10 লাখ কেস দিয়ে দিলাম আর বললাম 10 লাখ কেসকে তুমি 10 দিনের মধ্যে ডিসপোজ অফ করো, সেটা তো হিউম্যানলি পসিবল নয়, কোনোদিন সম্ভব নয়। আপনি 19 জন মাত্র জাজ এই ট্রাইব্যুনালে থাকছেন, রাইট? এবং সেটার নিষ্পত্তি আপনি কি করে 10 দিনের মধ্যে করবেন? তো সেটার মেনশন বারবার করে সুপ্রিম কোর্টের তরফ থেকে এসছে। কিন্তু সব থেকে ইম্পর্টেন্ট বিষয় যেটা, সব থেকে ইম্পর্টেন্ট বিষয়, ইলেকশন কমিশন অফ ইন্ডিয়ার থেকে একটা বিশাল তৎপরতা আবার দেখা গেল। এটা বলতে শোনা গেল যে দেখুন জাজ মহাশয়, আপনি বলেছিলেন ট্রাইব্যুনালি ফাইনাল, সরি আমাদের জুডিশিয়াল অফিসাররা ফাইনাল ডিসিশন নিয়ে নেবে। তারপর যখন অভিযোগ আসলো আপনি বললেন ট্রাইব্যুনালে যাবে। তার মানে কি, মানুষের গণতান্ত্রিক অধিকার যেন ভবিষ্যতে বজায় থাকে। আর বারংবার এই ভবিষ্যৎ শব্দটার উপর স্ট্রেস করা হয়েছে। ভবিষ্যৎ যেন, ভবিষ্যতে তাদের যেন ভোট দেওয়ার অধিকারটা বজায় থাকে। অর্থাৎ ট্রাইব্যুনালের এই প্রসেসটা অনগোয়িং প্রসেস, এটাকে চলতে দাও, যবে শেষ হবে তারপর যদি তার অধিকার বজায় থাকে তবে সে আবার ভোটার লিস্টে ফেরত আসবে। মানে বাংলার ইলেকশনে আপনার ভোট দেওয়ার অধিকারটা যদি আপনি বৈধ ভোটার হয়ে থাকেন আর আপনাকে কোনো কারণবশত ডিলিট করে দিয়ে থাকে, আর যদি ট্রাইব্যুনাল আপনাকে আবারও বৈধ ভোটার পায়, কিন্তু যেহেতু পুরোটা ভবিষ্যৎ সাপেক্ষিক, তাই বাংলা ইলেকশন 2026-এ আপনার ভোট দেওয়ার অধিকারটা মায়ের ভোগে। অ্যাবসলিউটলি ইলেকশন কমিশন অফ ইন্ডিয়া যেভাবে এটাকে রিজেক্ট করেছে আজকে বা অপোজ করেছে, তাতে বারবার করে যেন মনে হচ্ছিল যে ইলেকশন কমিশন অফ ইন্ডিয়া চান না যে এই মানুষগুলো 2026-এর বাংলার ইলেকশনে ভোট দিক। তাতে ইলেকশন কমিশন অফ ইন্ডিয়ার স্বার্থ কি আমরা জানি না। ইলেকশন কমিশন অফ ইন্ডিয়ার কাজ ছিল এসআইআর করে ভোটার লিস্টকে শুদ্ধিকরণ করা, রাইট? ভোটার লিস্ট শুদ্ধিকরণ করতে গিয়ে হাতির ঠ্যাং গাধার উপরে আর গাধার ঠ্যাং ঘোড়ার উপরে গেছে লজিক্যাল ডিসক্রিপেন্সির জন্য। আর সেটা প্রমাণিত হয়েছে একবার নয় একাধিকবার। কারণ যেই ইলেকশন কমিশন অফ ইন্ডিয়া প্রথমে বলেছিল যে ম্যাথ মানুষগুলোকে আর লাইনে দাঁড়াতে হবে না, কাগজ জমা দিতে হবে না, পরবর্তীকালে দেখা গেল যে ইলেকশন কমিশন অফ ইন্ডিয়ার ডিসিশন, যেটা আজকে সুপ্রিম কোর্টও রিয়েলাইজ করেছে যে যেভাবে লজিক্যাল ডিসক্রিপেন্সি বাংলায় করা হয়েছে সেটা হয়তো অন্যান্য জায়গাতে দেখা যায়নি। তাই ইলেকশন কমিশন অফ ইন্ডিয়া যে মানুষগুলোকে লজিক্যাল ডিসক্রিপেন্সি নামে লাইনে দাঁড় করালো, তারা অলরেডি বেশিরভাগ মানুষ কিন্তু ম্যাথ, তা সত্ত্বেও তাদেরকে কাগজের বোঝা নিয়ে লাইনে দাঁড়াতে হয়েছে এটা প্রমাণ করার জন্য যে তারা বৈধ। এবার এই যে সন্দেহটা ইলেকশন কমিশন কারোর উপর আনলো, রাইট, এই সন্দেহটার জন্য মানুষের তো কষ্ট হয়েছে। এবার এই কষ্টটা মানুষের কাছে কি কাম্য? একদমই নয়। কিন্তু তারপরও তাদেরকে কষ্টটা ফেস করতে হয়েছে, রাইট? সেই জায়গায় ইলেকশন কমিশনের কাজে যে ভুল ত্রুটি আছে এটা প্রমাণিত যখন জুডিশিয়াল অফিসাররা তাদের লেভেলেই 45% মানুষকে আবার ভোটার লিস্টে ফেরত পাঠাচ্ছেন। তার মানে ইলেকশন কমিশনের এই সন্দেহটা যথাযথ ছিল না এবং ইলেকশন কমিশন অফ ইন্ডিয়ার এই সন্দেহটা লেজিটিমেট ছিল না, রাইট? ক্লিয়ার? এরপরও ইলেকশন কমিশন অফ ইন্ডিয়া বলছেন যে যারা এখনো নিষ্পত্তি পায়নি তারা ভবিষ্যতের ভোটার হোক, ভবিষ্যতে তারা ভোট দেবে। কিন্তু বাংলার ইলেকশন 2026-এ তারা ভোট দিক বা না দিক ডাজন্ট রিয়েলি ম্যাটার। ইলেকশন কমিশন অফ ইন্ডিয়ার এই তৎপরতা নিয়ে কিন্তু একটা প্রশ্ন থেকে যায় যে কেন চান না বাংলার ইলেকশন 2026-এ এই মানুষগুলো ভোট দিক। একবার শুনুন আজকে ইলেকশন কমিশন অফ ইন্ডিয়া এবং জাজ এবং সিনিয়র অ্যাডভোকেট দিবানের মধ্যে কি কথোপকথন হলো, আর কেন এটা বারংবার স্পষ্ট হচ্ছে যে যারা বাদ যাচ্ছে তারা ট্রাইব্যুনালের কাছে আপিল পেলেও তারা আপাতত 2026-এর এই ইলেকশনে ভোট নাও দিতে পারেন। একবার শুনুন।
No, that's kindly one request. After the tribunal is decided in favor of the any persons, his name is cleared by the tribunal. Then, before the election, let's take it 23rd April, the first phase. Up to 21st, whatever the names are cleared by the tribunal, they should be allowed in the supplementary list.
Mr. Bhagwati, realize the
Presentation of people like
enormous
timeline.
pressure that will fall upon.
I am not saying blood.
Wait, my lord, the RP.
Once, as my lords have famously put, Millets,
Sir, kindly see, I am not talking about.
once,
Please appreciate the difference in the nature and quality of the proceedings before the
Well,
appellate
I am not-
tribunal vis-a-vis the verification of a judicial officer.
I am not talking about.
Judicial officer has verified in the form of an ex parte exercise. Today, it's here is a exercise with the requirements of adjudicatory natural justice.
Well, I am not
And
talking.
here, if this pressure is put on the tribunal, how
Well, I am not talking about the number of disposal. I am saying, Milord, let's take it. 100 cases have been disposed. Let's take it one case. 100 cases have been disposed of up to 21st. First page is 21st. That all that disposed of case in favor of the persons, Milord, they should be included in the supplement.
it is not,
That's I am trying to say.
So we are looking,
you have
we are
failed.
looking at a figure of around 26 lakhs. Appeals, let us say within 7 days will be crossing lakhs. And each and every one would love his case to be decided. 19 tribunals, a race to the finish by 15th of April will create chaos.
I am not saying, Milord, kindly. I am not saying about.
Another problem. Why this?
Every day, Milord, kindly.
Millets, your lordships were not even inclined to have an appellate provision initially. Said it's judicial officers, they will do it fairly, that's the end of it. Then your lordships said for future purpose, they should have that one. For that purpose alone it is.
Otherwise, my lord, the
They can't stretch too far.
Also see the hypothetical comparison, say with the appeal. Now civil court, assuming, has dismissed the suit. The first appellate court decrees. The objector has a right to go or
No,
not.
that is all right, Milord.
Precisely.
But kindly appreciate this, that let's assume, Milord.
Voting right, Milord. This is a voting right.
That right from the point.
Let's assume, Milord, tomorrow.
Let us first create that environment so that the tribunals are able to maximize the disposal.
Yes, yes.
Let us first create, we are not closing today also the matter.
Very well.
We are keeping it pending.
All right.
Just to take care of what you are apprehending or anything, we will keep the matter again.
Yes.
Fair enough, fair enough.
Yes, very well. But some supplementary list may be necessary if the tribunals are made functional.
That would amount to changing the dates prescribed.
No change in date.
And representation of people. With
You have
conduct of
changed
election rules.
You have changed everything. You have destroyed the democracy. You have changed.
That we have to say something. On destroying the
Yes.
democracy, we have to say something.
May I submit one thing, Millets, since they are talking about, Millets, I need to be,
Made elsewhere.
Millets,
Giri,
my lords gave on the last occasion, Millets, my lords permitted us to deploy forces as are required because the safety of the office is very important and we have been doing it in that process. Kindly similar yesterday speech. And just, I don't want to, Millets, kindly Millets, it's been said from Uttar
Can I-
Pradesh, CRPF people are coming to beat you. Be
Please,
prepared to
please.
face.
Let me,
Kindly have it.
let's not.
See Millets, can you see the speech?
Come to beat you.
Should I give another,
Very provocative speech.
should
yeah?
I give another?
They don't want a solution.
Then you have to say.
Kindly have it, Millets. And Millets,
Political
a
leaders. will
judicial
have to give-
officer,
Lord, it is.
a judicial officer was crying, please, anything happen
don't
to me,
mind.
save my children.
Kindly have
note
a
what-
only a minute. My lord, I also saw that.
আপনারা শুনলেন এই যে পুরো কথোপকথনটা সব থেকে ইম্পর্টেন্ট আসপেক্ট হচ্ছে এটাই যে ভবিষ্যতে এরা ভোট দিতে পারুক, পুরো ম্যাটারটা ডিসপোজ হোক, কিন্তু আপাতত ট্রাইব্যুনালে জিনিসটা গিয়ে নিষ্পত্তি যবে হবে, কিন্তু যেই জায়গাটা বারংবার সেটা সিনিয়র অ্যাডভোকেট কল্যাণ ব্যানার্জি হন বা সিনিয়র অ্যাডভোকেট শ্যাম দিবান হোক, বারবার করে বলেন, ইভেন সিনিয়র অ্যাডভোকেট কপিল সিবল, যে এটা আফটার অল আপনার গণতান্ত্রিক অধিকার। যদি আপনি ফাইনালি ভ্যালিডেটেড হন অ্যাজ আ ভ্যালিড ভোটার, তাহলে কেন আপনি এই ইলেকশনে ভোট দিতে পারবেন না যদি আপনার ম্যাটারটা ইলেকশনের আগে নিষ্পত্তি হয়ে গিয়ে থাকে, রাইট? এই জিনিসটা বারংবার কিন্তু মেনশন করা হলো জাজেসদের সামনে। একটা জিনিস ভালো, চিফ জাস্টিস অফ ইন্ডিয়া বললেন যে আমরা ম্যাটারটা আজও ক্লোজ করছি না, লেটস সি কোন দিকে ম্যাটারটা প্রগ্রেস করে। প্রগ্রেস অর্থাৎ 13th এপ্রিলে এই ম্যাটারটি আবারও ফেরত আসবে হিয়ারিং এর জন্য, সম্ভবত দুপুর 3টের সময়। তখন জানা যাবে যে এই ট্রাইব্যুনালে কতটা ম্যাটারতে কোন স্পিডে ম্যাটারটা এগিয়েছে, কতগুলো কেস নিষ্পত্তি হয়েছে, রাইট? এবং তাতে স্পিডটা বোঝা যাবে। বারংবার যেটা এই তরফ থেকে, অর্থাৎ রাজ্য সরকার বলুন বা তৃণমূল কংগ্রেস বলুন বা মমতা ব্যানার্জি বলুন, তাদের তরফ থেকে বলা হয়েছে যে কারোর যদি ভ্যালিড ভোটার হয়, আর কেউ যদি ভ্যালিড ভোটার হয়, তার থেকে এই ইলেকশন কেন, কোনো ইলেকশনে এই গণতান্ত্রিক অধিকারটা সাময়িকভাবেও কেড়ে নেওয়া যায় না। এবং সেইখানেই পয়েন্ট অফ অবজারভেশন, ইলেকশন কমিশন অফ ইন্ডিয়া বারংবার বলেছেন যে ট্রাইব্যুনাল তো ভবিষ্যতের জন্য করা হয়েছে, এই ইলেকশন গেল, কিন্তু ভবিষ্যতের ইলেকশনে যেন তারা ভোট দিতে পারে, সেটাকে মাথায় রেখে ট্রাইব্যুনাল করা হয়েছে। সুপ্রিম কোর্ট বলছেন কি, দুটো জিনিস, যে যদি আমি ফর্ম 6 অ্যাকসেপ্টেন্সেরও কাট অফ ডেট রাখতে পারি, ঠিক তেমনি আমার এই সব ইনক্লুশনের জন্যও, সে নিষ্পত্তির পর হোক নিষ্পত্তির আগে হোক, এই ইনক্লুশনস গুলোর জন্য আমাকে একটা কাট অফ ডেট রাখতে হবে, নইলে জগা খিচুড়ি হবে। আর দুই, সব থেকে ইম্পর্টেন্ট, যে আজকে যদি ট্রাইব্যুনালের উপরে কোনো টাইম বাউন্ড একটা প্রেশার দেওয়া হয়, তারা কি করে কাজ করবেন? 19 জন জাজ কি করে 20-26 লাখ কেসকে সর্ট আউট করবে, রাইট? তাই সেই জায়গায় যদিও বা সুপ্রিম কোর্ট এখনো ফাইনাল ডিসিশন নেননি, একটা ধোঁয়াশা রয়ে গেছে, বাট এটা নিয়ে কোনো ধোঁয়াশা নেই। যেভাবে ইলেকশন কমিশন আজকে এটাকে অপোজ করেছে, অ্যাজ ইফ তারা চান না এই ডিলিটেড মানুষগুলো, আপাতত যারা ডিলিটেড, তারা বাংলার ইলেকশন 2026-এ ভোট দিক, রাইট? থার্ড পয়েন্ট কি আছে? থার্ড পয়েন্ট, যে আপনি অনলাইন অফলাইন দুটোতেই যেমনটা বললাম আপনি রিসিট পাবেন। এবং থার্ড ফ্যাক্টর, যেটা আমি বলেছিলাম মালদার কেসে, খুব ইম্পর্টেন্ট অবজারভেশন, আজকে সুপ্রিম কোর্ট এসআইআর এর সঙ্গে যুক্ত যে প্রতিবাদ আন্দোলন হয়েছে বা একটা বিশৃঙ্খলা পরিস্থিতির সৃষ্টি হয়েছিল, আমি সেটা প্রতিবাদ আন্দোলন বলবো না, একটা বিশৃঙ্খলা পরিস্থিতি সৃষ্টি হয়েছিল, সেই বিশৃঙ্খলা পরিস্থিতির নেপথ্যে কে বা কারা আছে তার ইনভেস্টিগেশনের জন্য, হ্যাঁ, সেই ম্যাটারটার নিষ্পত্তির জন্য আজকে অফিসিয়ালি সুপ্রিম কোর্ট এনআইএ কে বলেছে তোমরা ইনভেস্টিগেট করো। ইলেকশন কমিশন অফ ইন্ডিয়া বলেছে এনআইএ তুমি পিকচারে আসো। এনআইএ নিজের রিপোর্ট কিন্তু খুব প্রফেশনাল ওয়েতে, সিলড ওয়েতে দিয়েছে জাজের কাছে, তাই কোনো আলোচনা এটা নিয়ে আসতে পারে না। কি সিলড কভারে লেখা ছিল রিপোর্টে আমরা জানি না। বারংবার বলছি, কাল যদি কোনো ন্যাশনাল মিডিয়া বা গদি মিডিয়া বলে আমাদের কাছে রিপোর্টটা আছে, তাদেরকে কিন্তু সুপ্রিম কোর্টের কাছে লায়াবল হতে হবে, যে কি করে একটা সিলড রিপোর্ট এনআইএ, যেটা অফিসিয়ালি দিয়েছেন চিফ জাস্টিস অফ ইন্ডিয়াকে এবং তার বেঞ্চকে, অন্য কারোর সঙ্গেও শেয়ার করা হয়নি, ইনক্লুডিং ইলেকশন কমিশন অফ ইন্ডিয়া, সেই রিপোর্টটা লিক হতে পারে না। তাতে যে জিনিসগুলো লেখা রয়েছে, কতজন মানুষ অ্যারেস্ট হয়েছেন, তারা কি কি ফাইন্ডিংস হয়েছে, তার একটা ডিটেল রিপোর্ট দিয়েছেন। ইনফ্যাক্ট সেই রিপোর্টটা পড়তে পড়তে সুপ্রিম কোর্টের চিফ জাস্টিস অফ ইন্ডিয়া এটাও বললেন, এই মানুষটাকে কি অ্যারেস্ট করা হয়েছে নাম না নিয়ে, এই মানুষটাকে কি অ্যারেস্ট করা হয়েছে, কেন অ্যারেস্ট করা হয়নি, আর যাদেরকে অ্যারেস্ট করা হয়েছে তাদের স্টেটাস কি, তারা জেলে রয়েছেন না পুলিশ কাস্টাডিতে রয়েছেন, আর এদের অ্যারেস্টটা কারা করেছে, রাজ্যের পুলিশ না এনআইএ। সমস্ত কিছু শোনার পর বললেন ইমিডিয়েটলি এনআইএ ম্যাটারটা নাও, যত ম্যাটার রাজ্যের পুলিশের কাছে আছে, যাদেরকে অ্যারেস্ট করা হয়েছিল তাদের সবাইকে এনআইএর কাছে হ্যান্ড ওভার করে দেওয়া হোক। এবং 3 নম্বর জিনিস বললেন যে এনআইএ যেন এটাও বের করেন কারা এই মানুষগুলো। খুব ইন্টারেস্টিংলি 3টে শব্দ ইউজ করেছেন চিফ জাস্টিস অফ ইন্ডিয়া। বলেছেন এই জুডিশিয়াল অফিসারদেরকে ঘেরাও করে রাখা, পথ অবরোধ করে রাখা, এটা মোটিভেটেড, প্রি প্ল্যান্ড এবং ডিপলি ইনস্টিগেটিং একটা অ্যাফেয়ার। 3টে ভেরি কনসিয়াসলি ইউজড ওয়ার্ডস। মোটিভেটেড মানে উদ্দেশ্য প্রণোদিত ভাবে এটা করা হয়েছে, প্রি প্ল্যান মানে যার প্ল্যানিং আগে থেকে করা হয়েছিল, এবং ডিপলি ইনস্টিগেটিং অর্থাৎ এরকম জিনিসটার প্রতিফলন হিসেবে অন্যান্য জায়গাতেও যেন এরকম জিনিস হয় তার একটা কিন্তু উস্কানি ছিল। তাই 3টে শব্দ মোটিভেটেড, প্রি প্ল্যান এবং ডিপলি ইনস্টিগেটিং চিফ জাস্টিস অফ ইন্ডিয়া ভেরি কনসিয়াসলি ইউজ করেছেন এই মালদার ঘটনাতে, এবং বলেছেন এনআইএ যেন এটার বলে না জট তক যাও আর নিকাল কে লাও ক্যা আখরি সচ, আসলি সাচ বলেছে একদম আসল ট্রুথটি বের করে আনো। এবং তার সাথে সাথে আজকে দেখার মতো দৃশ্য ছিল, এরকম শব্দ আজ পর্যন্ত কোনো বিউরোক্রেটের এগেনস্টে শুনতে দেখা যায়নি। বেঙ্গলের চিফ সেক্রেটারিকে তুলোধনা করেছে জাস্টিস জয়মাল্য বাগচি, চিফ জাস্টিস অফ ইন্ডিয়া সূর্যকান্ত, তুলোধনা করেছে। মানে বাচ্চাদেরকে যেমন রীতিমতো বকে না, প্রশ্ন করে তুই করিসনি কেন এটা, তোর এত বড় সাহস, এক্স্যাক্টলি ওই টোনালিটিতে সর্বোচ্চ আদালতের সর্বোচ্চ বেঞ্চ হেডেড বাই চিফ জাস্টিস অফ ইন্ডিয়া চিফ সেক্রেটারি অফ ওয়েস্ট বেঙ্গলকে রীতিমতো এক হাত নয়, দু হাত নয়, 10 হাত লাগিয়েছে এবং মনে করিয়েছে যে বাংলার বিউরোক্রেসির মধ্যে এরকম রাজনীতি ঢোকানো উচিত নয়। তুলোধনা করেছে এসপি কে, পুলিশ অফিসারকে, তুলোধনা করেছে ডিএম কে। ভেরি ইন্টারেস্টিংলি যাদেরকে আজকে ঝেড়েছে সুপ্রিম কোর্ট এই মালদার ঘটনায়, এই তিনজনকেই ইলেকশন কমিশন অফ ইন্ডিয়া কিন্তু বসিয়েছে আজকের তারিখে ক্ষমতায়। মনে করে দেখুন 17ই মার্চ এসপি চেঞ্জ করা হয় এবং 18ই মার্চ ডিএম চেঞ্জ করা হয়। খুব সম্ভবত, আমি যদি ভুল না করে থাকি, ডেটের হেরফের না করে থাকি, দুটো নোটিফিকেশন আসে, একটা 17ই মার্চ আর একটি 18ই মার্চ। একটা নোটিফিকেশনে ডিএম কে চেঞ্জ করা হয়, আরেকটা নোটিফিকেশনে এসপি কে চেঞ্জ করা হয়। তে মালদার এসপি, মালদার ডিএম এবং চিফ সেক্রেটারি, যাকে প্রথম দিন ইলেকশন অ্যানাউন্স হওয়ার দিনের দিন রাত্রেবেলা 12টার সময় চেঞ্জ করেছে, এই সমস্ত চেঞ্জেস কিন্তু ইলেকশন কমিশন অফ ইন্ডিয়া করেছে। আজকে চিফ সেক্রেটারিকে ঝাড়তে গিয়ে বলেছেন যে নিজেকে একটু নিচু করো। ওনাকে জিজ্ঞেস করেছে আপনাকে ক্যালকাটা হাইকোর্টের চিফ জাস্টিস ফোন করছেন, আপনি ফোন ধরছেন না। মানে আমরা যে ল্যাঙ্গুয়েজে কথা বলি সেই ল্যাঙ্গুয়েজে আলোচনা করতে গেলে রীতিমতো বোঝাচ্ছে তুমি কত বড় হনু, তুমি কত বড় হরিদাস, যে তোমাকে ফোন করেছে চিফ জাস্টিস অফ ক্যালকাটা হাইকোর্ট, তার ফোন তুমি ধরোনি। তার এগেনস্টে চিফ সেক্রেটারির ডিফেন্স হচ্ছে যে মাই লর্ড আমি হয়তো ফ্লাইটে ছিলাম। তখন চিফ জাস্টিস বলছেন যে না, আপনি ফ্লাইটে ছিলেন না, আপনি তখন দিল্লি থেকে ফ্লাইট থেকে নেমে গেছেন, আপনাকে চিফ জাস্টিস অফ ইন্ডিয়া ফোন করেছেন, আপনি তার ফোন ধরেননি। একাধিকবার ফোন করেছে, আপনি ফোন ধরেননি। চিফ সেক্রেটারি বলছেন ওনার কাছে হয়তো দুটো নাম্বার আছে। জাস্টিস জয়মাল্য বাগচি বলছেন যে ভাই আপনার কাছে যে নাম্বারটা আপনি দিয়েছেন সে নাম্বারটা তো কাজই করে না। চিফ সেক্রেটারি উনি বলছেন না, নাম্বারটা কাজ করে, এটা বিশাল সিকিউরড লাইন, অ্যাজ ইফ পেগাসাস ওই লাইনটা পেনিট্রেট করতে পারবে না, তাই সেই পার্টিকুলার নাম্বারটা দেওয়া হয়েছিল চিফ জাস্টিসকে। চিফ সেক্রেটারি অফ ওয়েস্ট বেঙ্গল, ওনাকে নাকি চিফ জাস্টিস অফ ক্যালকাটা হাইকোর্ট ফোন করে ফোনে পাননি, একাধিকবার ফোন করেছে, ওনাকে পাননি। আর আজকে সুপ্রিম কোর্টের সর্বোচ্চ আদালতের সর্বোচ্চ বেঞ্চ ওনাকে মনে করিয়ে দিয়েছেন যে ভাই নিজেকে অত বড় মনে করো না। এসপি কেও এই একই বিষয়ে বলেছে যে আপনারা যদি ফোনটা ধরতেন, আপনারা যদি কাজটা করতেন, তাহলে জুডিশিয়াল অফিসারদেরকে এতক্ষণ আটকে থাকতে হতো না। এসপি কে নাকি কেউ ফোন করেছে, এসপি বলেছেন আমি কি করব, মানুষের বিক্ষোভ। এটা কখনো হতে পারে? আর এই মানুষগুলো কারা? যাদেরকে ইলেকশন কমিশন অফ ইন্ডিয়া বসিয়েছেন। আর আজকে ইলেকশন কমিশন অফ ইন্ডিয়া বলছে মাইলর আমরা নিশ্চয়ই এটা নিয়ে একটা আপনাকে রিপোর্ট দিয়ে দেবো। The point of observation, চিফ সেক্রেটারি, ডিএম, এসপি, এই তিনজনকে তুলোধনা করে ঝেড়েছেন সর্বোচ্চ আদালত। বলেছেন তাদের গাফিলিতির জন্য মালদায় জুডিশিয়াল অফিসারদেরকে ঘেরাও হয়ে থাকতে হলো। কিন্তু যেই জায়গাটা কোনো ধোঁয়াশা নেই, এদের সবার অ্যাপয়েন্টমেন্ট কিন্তু ইলেকশন কমিশন অফ ইন্ডিয়া করেছে। আজকের তারিখে রাজ্য সরকার বলতে ইলেকশন কমিশন অফ ইন্ডিয়া, কারণ রাজ্যের অ্যাডমিনিস্ট্রেটিভ পাওয়ার ইলেকশন কমিশন অফ ইন্ডিয়ার কাছে। তাই যখন সুপ্রিম কোর্ট বলে রাজ্যের বিউরোক্রেসির মধ্যে রাজনীতি থাকা উচিত নয়, এটা বেসিক্যালি কিন্তু ইলেকশন কমিশনকে ডিরেক্ট করা যায়। কারণ রাজ্যে তো এখন রাজ্য সরকার নেই, একটা ইলেক্টেড গভর্নমেন্ট রয়েছে, কেয়ারটেকার গভর্নমেন্টের মতো। যতদিন না নতুন সরকার তৈরি হয় শপথ নেওয়ার পর, আপনি তো বলতে পারেন না রাজ্যে কোনো নতুন সরকার আছে, এখন তো মডেল কোড অফ কন্ডাক্ট। তাই মা বাপ ভাই যাই বলবেন এবং সরকার সবটাই কিন্তু ইলেকশন কমিশন অফ ইন্ডিয়া। তো সেই জায়গায় ভেরি ইন্টারেস্টিং আজকে যে ধরনের ঝাড় খেয়েছে চিফ সেক্রেটারি সর্বোচ্চ আদালতের কাছে, একবার শুনুন, একবার দেখুন।
Calcutta to my phone on 1st of April. I had come to Delhi for a meeting, and from 2 p.m. to 4:30 p.m. I was in flight, and till the evening no call had come to me, my lord.
Mr. Chief Secretary, the phone calls in all probability came in the evening after you had deboarded from your flight to Delhi. It would have been extremely helpful for the Chief Justice and the High Court administration if you had been kind enough to share your mobile number and other particulars.
My lord, my mobile number had been shared, but that number didn't
That
have
number is mostly switched off, Mr. Chief Secretary.
my lord, that number is not mostly switched off, my lord. That number is more secure and its connectivity is better, my lord. That's why during the attendance,
So high that the Chief Justice of Calcutta High Court or the High Court administration cannot access. So please lower yourself a bit so
My
that
lord.
ordinary minions like the Chief Justice of the Calcutta High Court can access it. At least he can have an access to the Chief Justice of the Chief Secretary.
my lord, I'm extremely apologetic regarding this miscommunication. I didn't
Please
have
write a letter of apology to the Chief Justice of the Calcutta High Court. This if you don't expect at least from the Chief Secretary that you refuse to acknowledge the Chief Justice of the High Court to whom for no reason.
I mean, এরকম দৃশ্য I really haven't seen in the past. For a chief secretary to be reminded by a judge that please lower yourself so that you are more accessible, it's not something we get to see or hear every day, but that exactly what has happened. While the context could be on Malda, but that also is a commentary on the bureaucracy and the bureaucrats which are now holding on to the government's administration under Model Code of Conduct and under the supervision of Election Commission of India. Probably that would also be a kind of a wake-up call for the Election Commission of India, that these officers, and through these officers, the accountability will eventually be parked at the doors of Election Commission of India. If that happens, what would be the response of Election Commission of India? We have to wait and see. For all our viewers who have been hooked onto our channel, we are grateful to you all. সবাইকে অসংখ্য ধন্যবাদ। লাস্ট 2.5 ঘন্টা ধরে আপনারা আমাদের সঙ্গে রয়েছেন, অসংখ্য ধন্যবাদ। আমরা আজকের এই হিয়ারিং এর হাইলাইটেড পয়েন্টস নিশ্চয়ই আলাদাভাবে শেয়ার করব যাতে কিনা আপনাদের ইজি হয় ইনফরমেশন অ্যাক্সেস করতে, কারণ ভুল ইনফরমেশন অনেক শুনবেন। ইনফরমেশনটা আপনারা নিজেদের মতো করে অ্যাক্সেস করতে যেন পারেন তার সুযোগটা নিশ্চয়ই আমরা করার চেষ্টা করব। For all those people who have joined us, connected with us, engaged with us, thank you so much. We are ending this live broadcast now, but do let us know your feedback about Election Commission of India, what transpired in the court today, and most importantly, what do you think should be ideal for those voters who are deleted for now, and if they undergo a trial process, and if that trial is pending before elections, and if there are mapped people in that list, should they be given a chance, a fair chance to cast their vote this election or not, is something we are eager to understand from you as your feedback. For now, thank you so much. We'll see you again very shortly in another live broadcast.